My lord, I may be allowed to move a matter tomorrow, my lord.
Is there any urgency?
My lord, bit of urgency is there.
Okay, we will try as the last item.
Yes. Obliged.
Yes,
I have two items of mentioning for listing. One will for 23rd of April, another will have a long date. I have given 5th May.
Lordship, I pray for listing of MSA appeals pending since 16 and 18. So in both the cases, we have filed IA, Lordship. So may come after vacation on 28th, Lordship. I'm pleased.
Wait, please, Your Lordship. Lordship, I beg to mention item number 32, Lordship. May I pray for adjournment, Lordship?
item number?
32 in order, Lordship. I have taken the consent of other side, Lordship.
I'm the respondent. Appellant with consent from the other side, best listing the matter after vacation.
Yes, Lordship.
They are allowed.
Highly obliged.
My lord, I beg
To
to
wait.
mention.
Mr. Sharma is.
My
Yes,
lord,
yes.
I beg to mention one IA, my lord, which was fixed today. IA is for release of deposit by the insurance company, my lord. Matter may be taken up on Friday, my lord, if it is possible, my lord.
Why not today?
Yes, if it is possible, my lord.
No, if it is listed today, we'll take it up.
Not listed, my lord, but
Not
it was
listed.
fixed today. Not listed. today.
It was fixed but not listed.
It was fixed, but not.
Today,
Okay, we'll try.
today,
Yes, my lord. Obliged, my lord.
Maybe I beg to mention listing in motion matter, my lord, on Friday, my lord.
no,
Friday.
Yes, my lord.
after vacation. Also.
My lord, there is urgency, my lord. There is
this is all right.
additional file a title should that, my lord. That was Withdrawal, but that was not liberty, my lord. So that are next date fixed on 24, my lord.
20.
24 to.
We will take it up on 21st.
21st.
My lord,
25th.
before, my lord.
No, before vacation, not possible.
Short matter, my
No,
lord.
no, maybe. Yes, do we?
Please, Your Lordship. My lord, as regard item 25, my lord. My lord, I have some difficulty today. May I pray, my lord, this matter be taken on 25th, my lord. I have the consent of my friend. my lord.
Mr. Dubey, learned counsel for the respondent. Number 123 with consent from the other side, press for listing the matter.
25th, my lord.
Mr. Bhagavate, any objection? No objection. Okay.
Please, Your Lordship. My lord, for item 30 and 31, I file an additional affidavit, my lord. This matter may, my lord, the record may be called for, my lord.
Okay.
Item 30 and 31. An additional affidavit is filed today. Highly obliged.
No, the item 14 of today's daily list, my lord, hearing on the order 41 item. So there is a connected item which has been wrongly listed before court number 21. I pray that, my lord, this matter be taken up along with the other RSA, my lord, two RSA, because they are arising out of the same judgment and decree, same parties, my lord. It may come up immediately after the vacation, if possible on 23rd. my lord. There is some urgency, the execution is pending. my lord.
You inform the other side?
I have.
Any objection, madam? No. Okay, as agreed by learned advocates of both sides, it is the matter shall be listed on
23rd if subject.
23rd
of April.
of April, along with RSN number
RSA 220 of 2024.
220 of
2024.
2024. As both are arising out of the same impugned judgment.
Same
order.
judgment and decree.
Judgment and decree.
Yes.
Okay.
May I, Mr. Lordship? I beg to mention two MAPs, Lordship.
I'm sorry, my lord. This is 216. That is RSA 220.
220.
No, this is 220.
This is 220.
216. my lord. Perhaps I have.
Okay.
Published.
May I, Mr. Lordship? I beg to mention two MAPs, Lordship. Both the matters are all pending matter, Lordship. So let it be come up on 29th of April, my lord.
No, in the first week of May. Okay, that
Any
from-
hearing date, my lord.
Huh?
Any hearing date, my lord.
8th May. 8th May.
Lordship.
My lord, I beg to mention item 15 and 16, my lord. In this matter, we have sent the affidavit for betting, my lord, with consent from other side.
You inform the other side.
Yes, my lord. Last chance may be given, my lord, for
Last
last
chance.
on several occasions they are taking time.
Okay. Mr. Pegu, learned counsel for the respondent.
Yes, ma'am.
In elementary education department with consent from the other side, first for listing the matter.
On 28th,
28.
28.
Fair.
interim may be continued.
Interim order pass earlier shall continue.
May I please, Your Lordship? Lordship, I would like to mention item number 13, Lordship. In this
13.
case, 13. In this case, Lordship, there is an order to amend the memorandum of appeal, Lordship.
Hmm.
There has been filed today, Lordship. It is not tagged with the record. Matter may come immediately after the Puja Bihu vacation.
Okay. As read for by Mr.
B. Kolita, on behalf of Mr. G.P. Bhomik, Learned Senior Counsel.
Mr. Kolita, learned counsel, appearing on behalf of Mr. G.P. Bhowmick, learned conducting counsel for the FLF. This shall list the matter on
Immediately after the Bihu vacation.
immediately after reopening of the vacation.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention for listing event, I pertaining to RSA matter, Lordship. Yesterday, Lordship, I mentioned a matter, but due to having not got a filing number, I mentioned matter memo was returned back, Lordship. But you have, Lordship, permitted the matter to be listed on tomorrow, Lordship. So can be later on tomorrow, listed on tomorrow, Lordship.
Tomorrow may not be possible.
So, Lordship, there is an urgency, Lordship, I have already mentioned.
Okay, tomorrow.
Much obliged, Lordship.
Yes,
May I please, Lordship? Lordship, I beg to mention, the prayer for listing of one CRPIO,
when?
If possible, Friday, urgency is, the matter was fixed, matter is fixed on, 11, in clerk court below,
On
11,
11th of May.
no, this 4 April.
Possible.
There are too many cases last day, Lordship. Already we have
Madam, we sought for, amendment of plain, the prayer of the petitioner rejected,
So your prayer was rejected.
rejected,
Okay, we'll see. There is no mass urgency immediately after reopening. On 21st.
on 21st.
May please, Your Lordship. Lordship, I beg to mention for 3 numbers of MSC, Lordship, 2 for orders, 1 for hearing on the 2nd week of May, Lordship.
Take it that from me. Yes.
May I please, Your Lordship? Lordship, I beg to mention 2 MFAs for listing. Kindly on 21st,
21st.
Under which column?
under orders.
Under 21st, we have given many cases, just wait. After a few days.
The execution case is excellent.
One on 24th, one on 25th. There are 2 cases, right? How many cases?
2 cases.
One on 24th, one on 25th. 24th April and 25th April.
My senior will be out of session. Kindly, if possible, on 20.
Okay, one on 22nd, one on 23rd. Okay.
Yes.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 24. Lordship, may kindly fix the matter after Bihu vacation, Lordship.
24.
24.
Sir, your good name?
AJ Tamuli.
H.J. Tamale, learned counsel for the respondent with consent from the other side, as well listing the matter immediately after reopening the application. There allowed.
That may be fixed, Lordship, after vacation.
After vacation, 1st May.
Lordship, obliged.
I am trying from listing in CRPIO tomorrow, Lordship, because the trial,
Tomorrow,
the matter is fixed on day after tomorrow in the trial court.
maybe. Who is responsible for delayed filing of the petition?
Lordship. Case has proceeded expert, Lordship.
Hmm?
I have accordingly filed the approved petition.
Hmm.
That petition was rejected.
When the next date is fixed?
11, Lordship. 11 April.
For
expert evidence of the plaintiff side. I am the principal defendant. I did not receive any notice. As such, I could not appear, Lordship. And accordingly, I have filed an application that was rejected.
okay, on Friday, we'll try as last item.
Much of it.
Item 4 withdrawal, item number 1.
My lord, in this case, the matter has been settled outside the court, hence this matter may kindly be closed at this stage, my lord.
Okay, Mr.
BC Chaudhary, appearing on behalf of PK Chaudhary.
Mr.
BC Chaudhary.
PC
Chaudhary.
Chaudhary, learned counsel appearing on behalf of Mr.
PK Chaudhary.
P.K. Rosuru, learned counsel for the FLA. Submits that. You are for?
I'm for respondent number 1, Lordship.
I think I called to heard Mr. So and so, learned counsel for the appellant, and also heard Mr. So and so, learned counsel for the respondent. It is submitted at the bar. That letter has been settled outside the court. And as such, you want to withdraw the same?
Yes, my lord.
And that he has the instruction to withdraw the matter. And the learned counsel for the appellant submits that he has the instruction to withdraw the matter. And accordingly place for according him permission to withdraw the same. That is accordingly allowed. Yes, RSA stands dispose of on withdrawal.
So item for motion, item 2.
May please, Lordship. Lordship, in this matter, we have tried for a possible settlement on the claimant side. But the counsel for a claimant is quite adamant, Lordship, and they are not ready for the settlement. Now, issue here is that, Lordship, deduction of 20% tax while depositing the compensation amount, Lordship. And we have challenged this order of the Land Tribunal, which is Annexure 1, page number 11, Your Lordship, in our CRP, where the Land Tribunal has opined that the act of deducting 20% tax amount is not justified, and we are directed to pay the entire amount by 24/9/24, Lordship. And in this regard, Your Lordship requires some documents from our side, why we have deducted 20% tax, Lordship. I want to submit 2 documents here, Lordship. Did you know? Lordship, firstly, Lordship can peruse the PAN card, Lordship. Here, Lordship, the claimant's name has been written as Rukmini Tiwari, but in the particular case, she is Rukmini Devi, Your Lordship. That's why system did not accept this PAN card, Lordship. And by the number also, some other person's name has been reflected, Lordship. This number is not taken in the system, the PAN card number, and she has submitted, the claimant has submitted the PAN card of a different name. Might have she has not corrected the PAN card, Lordship. That is in the name of Rukmini Tiwari, and for this reason, Your Lordship, because there is statutory provision under the Income Tax Act, that is Section 206AA. I can submit also. It is statutory provision. That's why we had to deduct the 20% tax. That is Section 206AA, the Income Tax Act 1961, which requires the requirement to furnish permanent account number. Here it is stated, Your Lordship, that 206AA, subsection 1. Any person entitled to receive any sum or income or amount which his tax is deductible under chapter so and so shall furnish his permanent account number to the person responsible for deducting such tax, failing which tax shall be deducted at the higher of the following rates, Lordship. That is usually, Lordship, if PAN card is accessed by the system, a 10% amount is deducted. If the amount of interest is more than 50% in the particular financial year. Here, that's why, Lordship, we have rightfully deducted the 20% of the tax amount. Lordship, it's a beneficial legislation, Lordship. The matter is delayed, Lordship, both party will suffer. We have tried our best to settle this matter, Lordship. We had contacted the Learned Counsel, but he's quite adamant that he's not ready to settle. He's not ready for the settlement, Lordship. Lordship, if the claimant side submits the corrected PAN card, we are ready to deduct 10%. We're ready to deposit the additional 10%, Lordship. We are obliged to honor the award, Lordship. We are legally obliged.
What was the direction of the tribunal?
Tribunal said that this act is wrong. 20% deduction is not wrong, Lordship. We cannot deduct 20%, and there is judgment also, Lordship. The court says,
So the
the amount-
deducted amount is a 1,92,851 rupees.
Lordship. Lordship,
So
we are
rest of the
also,
amount that you have paid to the claimant.
yes, we have paid 24,29,004 rupees. We have deposited.
Okay, let notice go at this instance. What to do?
Lordship.
Heard Mr.
Lordship.
P.J. Burman, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 28.
1 second. That is annexure 1. That is, award is 11/5/23. Award dated 11/5/23 for an amount of rupees 16,57,600.
22nd of August 2024, passed by the learned additional district judge FTC number 1 Margarita in money execution case number 2 of 2020. Rejecting the petition number 465 of 2024 filed by the money execution case number 2 of 2024 full stop. It is to be noted here that by the impugned order dated so and so, the learned additional district judge FTC Margarita in money execution case number 2 of 2024 has dismissed the petition number 456 of 2024 passed by the petitioner as judgment date. But you have to deposit 50% of the awarded amount, this amount before the receipt of this court.
Let's see, we have deposited already 24 lakhs.
No, this amount against which this petition is prepared.
Lordship, we have, it is a civil revision, Lordship. We have only challenged that. order.
Maybe.
Only challenged that order, Lordship.
Only?
Only challenged that order, Lordship. Where we have directed to deposit the entire amount, the deducted amount. In that regard, I can satisfy your
the
Lordship.
deducted amount, 50% of the same has to be deposited before the receipt of this court. Peruse the petition and the documents placed on record and also peruse the impugned order dated 22/8/2024. Let notice be issued to the respondents returnable in force. That be taken by registered post with AD and also by usual process we can return to that.
Until next that, Lordship, that execution case may be stayed. Because it is going on, Lordship.
The learned counsel for the petitioner submits that the learned additional district judge FTC Margarita as member MSCT in MSC case number. What is the number of the MSC case?
Lordship. Got reflected in the order. It is
What
only.
is the judgment of MSC member MSCT Margarita?
Lordship. It is not with me, Lordship. Yes. It's MSC case number 32 of 14.
In MSC case number
32 of 14.
14.
14.
English circles. Pardon? Yes, a member MSCT has directed the petitioner herein to pay a sum of rupees 26,21,855,
Yes.
paying the compensation to the claimant. And thereafter, The petitioner herein deposited a sum of rupees 24,29,004 rupees after deducting the income tax. But the learned uh, but the learned additional district judge FTC number 1 Margarita in money execution case number so and so has directed the petitioner to deposit the entire amount deducted as income tax. And that the execution case is going on. And there is a requirement for staying the aforementioned proceeding. We are taking note of the submission of Mr. Burman, learned for the petitioner. Further proceeding of execution case number 2 of 20, money execution case number 2 of 2024 stands state till returnable debt. Subject, however, to a sum of rupees, the 50% of the sum of rupees 1,92,000. 851 rupees being deposited before the registry of this court within a period of 1 week from today. List the matter after 4 weeks.
Highly obliged, Lordship.
Lordship, as per Lordship direction, Lordship, we have deposited the 50% of the audit amount. No. Direct.
Oh, the notice was already
In
where is
MSc
the
FE,
notice? Where is the notice?
notice of execution, Lordship, will find at page 66.
Awarded amount was 15 lakhs 37,000.
And the page 72, Lordship, is the list they have attached, Lordship.
So now what is your prayer in this petition?
Lordship, prayer is only to Lordship stay the further proceeding of the execution and to Lordship restore the properties they have attached. Lordship.
No, they have already executed the writ, no?
Lordship.
They have already executed the writ.
Lordship, yes. As per order of the executing court, Lordship, they have attached the properties of this movable property of this petitioner's office, Lordship. That is at list of Lordship page 72. They have Lordship attached all the movable properties like computer, CPU, monitor, etc. Now this is a public office. Now it is Lordship not working at all because of attaching these properties, Lordship. We have preferred the appeal Lordship against the said award, and that because of the delay petition is still pending. Lordship will find the order of this noble court at page 63.
Page 66.
63. This I is for condoning the delay, and this honorable court has issued notice.
Heard Mr. Polita, learned counsel for the petitioner. Person to order of this court dated 7/4/2025, Mr. Polita has produced the notice dated 19/1/2024, which notice you have enclosed it at page number 66. No, on the other day you have not produced the notice.
Notice of Lordship.
This notice, Annexure 3.
Annexure 3 is the first notice, Lordship. The executing court has issued. This is the notice issued by executing court, Lordship. MSC Miss Execution Case number 1 of 2024.
No, the notice dated 19.
Yes, this is the Lordship. This is the notice. 19 Lordship will find the left hand side of the bottom portion, Lordship. The seal is there, 19 January 2024.
No, in the order dated 7/4/2025.
Yes, Lordship.
It is reflected as
About this
19/1.
notice, about this notice also. About this notice only, Lordship.
And also produce the deposit slip of 50% of the awarded amount before this court. Before this court. Mr. Polita further submits that the office of the petitioner is a public office, and due to and because of the attachment of the movable and movable properties, the office could not function. No, whether the computers are being used.
Lordship, all these were Lordship functioning, but after seizing this, now it office is sitting Lordship lying idle, Lordship, without any function.
People who like to. And as such, there is a requirement for releasing the attached articles so that the office can function. And that challenging the award of the learned member motor accident claim tribunal 1 MSc appeal is also being filed before this court. And the same could not, the same is pending for condemnation of delay. And therefore, Mr. Polita has contended to allow this petition. The submission of Mr. Polita, learned counsel for the petitioner, needs further consideration at this stage. Notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Since the petitioner has deposited 50% of the awarded amount, further execution proceeding of MSC case number.
MSC execution, mis-execution case number 1 of 2024.
This execution case number 1 of 2024
Yes.
stands state. And the article already attached shall be released till returnable date.
Lodge. By the
List the matter after 4 weeks.
Lordship, one of the immediately after submitting the copy of this order, Lordship, they will release the article. Lodge.
Okay, the petitioner shall obtain a copy, certificate copy of this order and produce the same before the
Civil Nazir, Lordship.
before the civil Nazir.
Tinsukia. Lordship.
Tinsukia. For doing network.
Lodge. 4. Oblige.
Yes, please, Lordship. 482 petition matter. The complaint lodged against the Parthavatim Bordoloi, Salam Ali Hafizur Rahman, etc. matter, those who are already released on anticipated bail matter. I am not the FIR named accused matter. So, my humble prayer, in petition may be allowed to go on bail matter. He is very much innocent man. He is not named FIR named accused man. FIR is page 13.
Mr. Sharma?
My lord, Kesari at this stage, my lord.
Kesari.
My lord.
Or Mr. B. Islam, learned counsel for the applicant. This application under section 482 of the BNSS 2023 is prepared by the applicant. Namely, Rizwan Ahmed, who has been apprehending arrest in connection with Jagirut case number 9 of 2024 under section 120B, 420, 468, 470, 187. Having heard the submission of learned counsel for both the parties, it is provided that Mr. Sharma shall produce the case diary before this court on 21st.
My lord, 21st.
But in the meantime, my lord, interim may be given, my lord. Interim may be awarded, my lord.
Pardon?
Interim, my lord.
No.
For admission,
Earlier it was rejected.
No, all those petitioners, petitioner already released on interim bail, my lord.
Maybe, but we will peruse the case diary only thereafter we will consider it.
By the court.
Who accused?
Order.
Item 5 for admission order matter.
Lordship, here in this matter, Lordship, the affidavit is going to be filed during the course of the day. So, Lordship, may I pray this matter to be listed immediately after vacation, Lordship, any day. Lordship.
We will file the affidavit today.
Yes, Lordship.
Lordship. Heard Mr. Arpakam, learned counsel for the petitioner. Then also heard Mr.
The Upaman.
The Upaman, learned standing counsel for the higher education department, and Mr. N. Upadhyay, learned counsel for the respondent number 3 and 4. Mr. Upaman submits that he has prepared the affidavit and he will be filing the same during the course of the day and based on listing the matter immediately after reopening of the petition. There is allowed, rest shall list the matter immediately after reopening.
I am praying for a date loss. So items
In a part-heard matter, it will automatically. Item 6.
Oblige.
May I please, your lordship?
Yes,
Lordship, in this matter, we need some time, short time may be given to file our affidavit in reply, lordship.
heard means
Vehicularity.
learned counsel for the petitioner and also heard Ms. for respondents in higher education department and Madam you for
Dr. P. Agarwal for the UGC.
UGC. The learned counsel for the petitioner submits that she may be granted some more time to file affidavit in reply to the affidavit in opposition filed by the respondent in higher education department. Where is allowed? This is always the matter. When?
Lordship, date may be fixed after beautification.
Immediately after beautification. To
Okay.
file it as soon as practical.
Item 7, part-heard matter.
Please, your lordship. The last occasion they were not time to file objection, your lordship. Certain instruction, your lordship.
After some time, Miss.
Item 7.
Lordship, here the instructions are awaited, your lordship. Last time we were asked to place instructions. Lordship, I pray for some time, your lordship.
So in that case, immediately after Bihu,
Immediately after.
Bihu, lordship.
Heard Mr.
As Gautam, your lordship.
Yes.
Gautam.
Gautam, learned counsel for the petitioner and Madam Musari for respondent authorities in elementary,
The lordship secondary education.
secondary education department. Musari submits that instructions are still awaited. And press for listing the matter immediately after reopening of the application. Here alone. This is a list the matter immediately after reopening of the application.
Lordship, a date may be fixed, your lordship.
Take it that.
Item 8, part-heard matter.
For timing, lordship, my senior late, lordship.
Item 9.
May it please, your lordship. The petitioner is aggrieved by the order dated 29th October 2022, whereby my prayer for filing, allowing me some time to file my WS was rejected. What happened, your lordship, is that I as a plaintiff filed a suit against the present respondent, your lordship. The defendant, the present respondent appeared and contested it by filing their written statement come counterclaim. They filed their written statement come counterclaim on 30 July 2022.
When?
30 July. 30, your lordship, 30 July 2022. So after they filed, but that was not served upon us because, and the date was fixed on 26 September 2022. Your lordship may kindly come to Annexure 3, Annexure 2, page 24, your lordship. Page 24. Your lordship will find the certified copy, the photocopy of the certified copy, your lordship. This is the written statement counterclaim. And if your lordship sees that received by so-and-so on 26/9/2022 on the left-hand side, that is on the date fixed for filing the written statement against the counterclaim, your lordship. So thereafter, your lordship, the plaintiff, the present petitioner sought time which was allowed and a date was fixed on 29th October 2022. So on 29th October 2022 was the next date, and on that day, the petitioner filed an application. Your lordship will find it in Annexure 3, page 70. If your lordship comes to page 70, your lordship, will see that they filed an application allowing some time since a new set of councils were appointed. So that the above noted suit is fixed today for filing WS against the counterclaim filed by the defendant number 123. That the plaintiff has engaged his new set of advocates to conduct his suit today itself, and accordingly the new set of advocates have filed wakalatnama. So this was the case, and according that the new engaged. So what happened, Your Lordship, since new set of Your Lordship?
They have filed counterclaim on 13/7/2020.
2022. But the same was not provided to us. It was only on the date fixed for.
No, it was filed on 38/7/2020.
37/22.
Yes, so when did you receive it?
I received it on 26th September.
From where you have received it?
From the court itself.
Yes, Mr. Singh.
Lordship, we have no objection against, Lordship. Lordship, we have no objection against the CRP filed by the petitioner, Lordship. Lordship,
No objection.
no objection. I have instructions that we have no objection. Lordship may dispose of the matter, Lordship.
Heard Mr. Kusilal, learned counsel for the petition. And also heard Mr. Singh, learned counsel for the respondent. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 9/10/2022.
Your Lordship, there is some mistake. It is 29/10/2022.
Who corrected it?
Your Lordship, it was actually earlier there was the filing was done by.
Where is the initial?
Your Lordship, I'm not aware, but the correct date is 29th October 2022. We came later on. I was engaged later on.
Where is the impugned order?
Impugned order, if your Lordship finds, it's page 80, Your Lordship. If your Lordship sees, even there, the court copy, Your Lordship, there is some mistake. That is 29/12/2022. But prior to that page, if your Lordship sees, the order which was given passed on 26 September 2022, fixed 29/10/2022 for WS and counterclaim. So your Lordship, thereafter this order was passed. Probably this was inadvertently typographical mistake, Your Lordship, 29/12/2022. But
Where is the translated copy?
Translated copy is, Your Lordship, on page 74, Your Lordship. Page 74. There are some mistake, Your Lordship, which has not been corrected probably, because this was filing was done by earlier some other advocates. We appeared later on. Your Lordship will find in wakalatnama. I have to take the mistakes, the typographical mistake.
The petitioner has challenged the correctness or otherwise of the order, impugned order dated 29/10/2022. Caused by the learned Munshi Kamruk Amingao. It is to be noted here that by impugned order dated so and so, the learned Munshi has dismissed the petition number 2726 filed by the petitioner herein as plaintiff for allowing him time to file a written statement against the counterclaim filed by the respondent herein on the ground that he has engaged new legal counsel. Legal counsel. Mr. Procedural learned counsel for the petitioner submits that the petitioner has received counterclaim on 26/9/2022. 26/9/2022. Though the same was filed on 30/2022. And as the earlier set of counsel were since the written statement could not be filed in time. And therefore, Mr. Osilal has contended to allow this petition. As the same learned counsel for the respondent submits that he has no objection in the event of setting aside, in the event of allowing this revision petition by setting aside the impugned order dated 29/10/2022. Further, having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents as on record, and also perused the impugned order dated so and so. It appears that from the annexer, what is the number of annexer of this petition? Now of this counterclaim.
Your Lordship,
What is the number of annexer?
there are 4 annexures, Your Lordship. The first one is the copy of the plain annexure. 1 is the copy of the suit, Your Lordship. Annexure 2 is the written statement counterclaim. Annexure 3 is the petition.
Where you have marked it?
Yes,
as
Your
annexure
Lordship.
2. Where you have marked it as annexure 2?
Annexure 2, Your Lordship. Page 45, Your Lordship. Page 45. They have given a type as well.
It appears from the annexure 2 at page number 45, as well as from page number 24 of the petition that the petitioner herein has received the copy of counterclaim. Written statement cum counterclaim on 26/9/2022. But the impugned order was passed on 29/10/2022. And what is the outer limit?
Yes, Your Lordship.
What is the outer limit for filing this counterclaim?
It's 30 days. It can be extended up to 90 days because the rule of WS will be applicable even for filing WS against the counterclaim.
The Procedural learned counsel for the petitioner submits that though the limit for filing the written statement against the counterclaim is 30 days, yet the same can be extended up to 90 days. And the said period has not yet been expired here in this petition, no, here in this case. And as such, the impugned order is illegal and arbitrary, and therefore Mr. Procedural contended to set it aside. But having carefully gone through the petition and the documents placed on record, I find substance in the submission of Mr. Posela, learned counsel for the petitioner. And taking note of the submission of Mr. Posela and also of the learned counsel for the respondent, and further considering the facts and circumstances on the record, this court is inclined to allow this petition. The impugn order dated so and so is then set aside in clause. And consequently, the learned trial court is directed. Where is your counterclaim? Oh no, where is your reply here, written statement?
No, I have not filed the written statement. I sought a time and the matter was fixed for issue, your lordship. Your lordship will file the order with a
Usually
29.
you, along with the petition, you have to file the written
No,
statement.
your lordship, I prayed, if your lordship goes page 70, I have stated the ground that I am appearing, I need some time to file the WS.
The petitioner is directed to file a written statement against the counterclaim filed by the when the next date is fixed.
Lordship, the proceeding has been stayed.
Stayed.
Your lordship, a date may be fixed for appearance and thereafter a date may be given within which we can file our complaint.
The parties are directed to appear before the learned trial court on
25th April.
25th
2
April.
weeks.
And the learned trial court is directed to grant directed to accept the WS filed by the petitioner hearing on that day, and thereafter to proceed with the matter in accordance with that.
Your lordship, is it the 25th April we will be appearing? Or we have,
No, on that day you file the,
then your lordship kindly, because since we have to communicate and after the order, some more dates, your lordship, in the month of May, if your lordship kindly give it.
no, not necessary.
Because there is due vacation and the order will be communicated, your lordship. So, or some
Order will
one
be
week more
uploaded
time may
today
be given.
itself.
Your lordship,
Order will be uploaded today itself.
your lordship, no, I was just saying that one week,
No, no.
one more week may be given because there is Bihu vacation. So just after the opening of the Bihu vacation. So only 1 week extended,
No,
your lordship.
no,
Instead of
sorry.
25th, it may be given in the first week of May, your lordship.
Sorry. Yes, next item.
Item 10.
Lordship, interim order is there, Lordship, for stay. Interim may be vacated.
No,
So that is
that will
already
be merged with the final order.
Item 10.
obliged.
Yes, your lordship. The petitioner preferred this appeal against the order dated 9/2024. Impugn order at page 54. My lord, the petitioner filed a suit against the respondent defendant, and respondent defendant one has appeared and filed her written statement before this trial court. And thereafter,
Let notice go, Mr. Bora.
my lord,
Let notice go at this instance.
my lord,
Part Mr. L.K. Bora, learned counsel for the appellant. This appeal under section
Question 96.
96 of the Code of Civil Procedure is directed against the order dated 9/12/2024. Passed by the learned civil the senior division number 2, Kamrut and Guwahati in title suit number 16 of 2021. It is to be noted here that by the impugn order dated so and so, the learned civil the senior division number 2, Kamrut Guwahati has dismissed the suit
On the point of limitation.
on the point of limit, being the suit barred by limitation. Admit notice to the respondents returnable in 4 weeks that be taken by registered post with KD and also by usual process within a week from today. Call for the record from the SSL, call for the record from the learned trial court, list the matter after 4 weeks.
In the interim order may be stayed. I filed an IA.
Let notice go at least. I also. Third, Mr. L.K. Bora, learned counsel for the applicant. His application under Order 41, Rule 5. Read with Section 151 of the Code of Civil Procedure. Is prepared by the applicant for staying operation of the impugned order dated 9/12/2024. Passed by the learned civil judge, senior division number 2, Kamrup and Guwahati, entitled suit number 16 of 2021. Issue notice to the respondent opposite party, returnable in 4 weeks. Step be taken by research post with AD and also by result process. And I will come to the list of the 4 weeks.
11.
Lordship. Lordship, and this is an appeal for enhancement, Lordship.
For enhancement.
Enhancement, Lordship. Lordship.
Is a injury case or death case?
Injuries, Lordship. The 45% disability was there, Lordship. That was
45%.
reduced to 20%, Lordship. By the learned tribunal, Lordship.
Yes, so what wrong with the order?
Lordship, as per the recent.
Because court is not supposed to accept the disability certificate issued by the doctor.
But that
Court
has been
has
accepted,
to-
Lordship, but it has been reduced to 20%.
Yes, court can determine the functional disability.
Lordship, in a recent Supreme Court judgment, Lordship, the court has held that without a reassessment of the injury, the learned tribunal cannot reduce the disability percentage, Lordship. There should be reassessment during the trial.
The disability percentage may be same, but this functional disability, court has the power that the decision is there.
Lordship.
Rajkumar, Ajay Kumar, or like that, one decision is there.
Lordship, and in a recent judgment, Lordship, it has been specifically.
No,
held-
maybe, but the earlier judgment cannot be ignored.
Lordship, there are other grounds also, Lordship. That's why I'm required, Lordship.
Okay. Heard Mr. Didas, learned counsel for the appellant. This appeal under section 173 of the MV Act is directed against the judgment and award dated 12/12/2024 passed by the learned member, Motor Accident Claim Tribunal, within bracket MSCP, Gwalpar. It is to be noted here that by the impugned judgment and award dated so the learned tribunal has directed the respondent. Respondent number?
Respondent number 1, Lordship.
Respondent number 1 to pay a sum of rupees 6 lakhs.
6,05,792
as the compensation. As the compensation with interest at the rate of 7% per annum from the date of filing the.
From the date of evidence, Lordship. That is one of the grounds, Lordship.
When the claim petition was filed,
It was filed, Lordship, date is not there, Lordship, in the year 2022, Lordship. 22.
22. So immediately thereafter, you have not filed your evidence in affidavit.
We have
You
filed.
have filed it on only 27/7/2023.
Lordship, subsequently, the respondent appeared, they filed their WS, and after the closure of those proceedings, we have filed their evidence. in it.
Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and award dated so and so. Admit issue notice to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by legal process within a week from today. Justice will call for record from the learned tribunal. This is the matter of 4 weeks.
The appeal may be admitted, Lordship.
Admitted. Item 12.
My lord, there is a delay of, my lord, 234 days in filing the claim petition before the tribunal. That's why it was rejected, my lord. He was medically confined to bed, my lord. Medically, he went to Madras.
Whether there is any provision for condemnation of delay. in
Now,
the
my lord, there
event-
is judgment of apex court on this regard, my lord. That if FIR is filed in time and a GD entry and the police report is filed, then it is no question of delay. It is the duty of the automatically court of the claim court.
That's all right, whether you have filed any FIR,
Yes, yes, FIR was filed, my lord.
whether that FIR is part of this record,
It is not here.
then
It is with the my claim petition. It is there. One accident took place, my lord, on it was on accident took place, my lord, on 20/12/22. FIR lodged on 10/5. The GD entry was made on 20/12/22. Same day.
Mr. Biswas, you filed the FIR.
If you're also, I will file on the affidavit. I'll file it.
Heard Mr. S. Biswas, learned counsel for the appellate. This appeal under section 173 of the MPA is directed against the judgment and order dated 29/1/2025 passed by the learned matter of claim tribunal based on the in miscondemnation case number 1 of 2024. Mr. Biswas, learned counsel for the appellant submits that in filing the claim petition before the learned tribunal, there was delay of 234 days, for which the appellant herein has preferred one petition for condemnation of delay of 230 days, 34 days, upon which the learned tribunal has registered a miscase, being miscase number 1 of 2024, and therefore hearing both the parties, the learned tribunal has dismissed the same. Mr. Biswas, referring to a decision of Honorable Supreme Court in the case of
It is, my lord, my lord, Gohar Mohammed versus Uttar Pradesh. Latest case, 24, my lord.
furnish it to the court master. The case of Gohar Mohammed versus
Uttar Pradesh.
State of Uttar Pradesh reported in
Reported it is in Supreme Court. I have got it from panel. Please show it.
in civil appeal number 9322 of 2022, arising out of special leave petition within bracket C number 32448 of 2018. Submits that though there was delay in filing the claim petition, yet the claimant herein has filed. No, the appellant herein has filed on FIR before the concerned police station immediately after the accident, and the said FIR has to be and the date has to be counted from the date of filing that FIR. But Mr. Biswas has not
filed the FIR
enclosed the said copy of FIR along with his appeal. Mr. Biswas submits that he may be granted some time to bring on record the FIR by filing an affidavit. There is accordingly allowed recessal is the matter after vacation.
Item 45.
May please, your lordship.
Yes.
My lord, the issue involves in the whether the president of a SNDC is a local.
So Mohanto, you work for respondent number? Six. Have you filed your affidavit?
Yes, ma'am, I have filed my affidavit, yes, ma'am.
When?
Page 87.
But there is one office note that indicates that no affidavit in opposition has been received.
My
from
lord,
the
my lord, the department is required to file affidavit as per the order dated 29/11/2023 and 9/2/2024.
Defining who is a local resident, Your Lordship, and that instructions we have not received, Your Lordship. And Lordship, if I may say, Your Lordship, because this is, we are all disputed questions and facts, Your Lordship, whether who is the resident.
No,
Because-
maybe you file your affidavit as per direction of the court.
My lord.
Lordship, defining a local resident, Your Lordship, I have like asked them to give the instructions, but till date we have not received. Because defining a local resident, maybe they are finding it difficult, Your Lordship, because whether he's a local resident or not, Your Lordship, that can be only through like, because that has to be done, the documents has to be seen, Your Lordship.
No,
whether-
that is not dispute, my lord. He is local or local is not defined in this circular, my lord.
No, defined, Your Lordship.
So that is not disputed that, my lord, I am not from Kokrajhar district, he is from Dhoburi district. What happened in this case, my lord, there is, my lord, the school was situated in the border of the, my lord, Dhoburi and Kokrajhar district. Most of the school is within the district of the, my lord, Dhoburi, but most of the students from, my lord, Kokrajhar.
No, my lord, not most of the student, my lord. And
Then
my lord,
Let him complete.
there is affidavit, that's why I'm saying. Then, my lord, there is a circular that the president of the managing committee must be a local person. But local in the context of that, my lord, that is nowhere defined.
That's
But there is no bar that he is from the another district. There is no bar that is a clarified by, there is a one RTI reply I have got, my lord, that is not been defined. That's why, my lord, is this managing committee was constituted as per the circular. Your lordship kindly see that my learned friend says that there is a disputed question. Disputed question, it is not dispute that I am from the Dhoburi district, Kokrajhar district, he is from the Dhoburi district. There is no dispute, my lord. So there is no document to see that, my lord. But that context of that, a person, although office is situated in the Dhoburi district, but school is situated in Dhoburi district, the person from, my lord, Kokrajhar district can be treated as a local or not, my lord. So that, my lord, in the circular is totally silent. Your lordship kindly see the circular based, that is annexure 5, page 27. Page 27, my lord.
Relevant person?
Relevant portion, page 28.
Yes.
One local educated deputed citizen having no political career. So in this case, only local says, but whether it is a from another district, there is no bar.
Kokrajhar district, it is not defined.
Non-defined, but school is situated, that was inspector of school, my lord, your lordship kindly see, inspector of school wishes file affidavit, file, my lord, in that affidavit says, my lord, because I was also a student of that school, my lord, earlier. Because earlier years of only Dhoburi district, 1982, my lord, is probably Kokrajhar district was from, my lord. So in that context, most of the student, my lord, this affidavit filed by the inspector of school, my lord, your lordship kindly see, my lord, clearly stated that most of the students from so that's why in that context, my lord, who according to rule, my lord, who will how it will define this local, they were asked to, my lord, file a submitted affidavit.
Why that question arose?
Arose, my lord, he is challenging my nomination. But he is not challenging my appointment, my lord. I was already appointed as a, my lord, appointed as a president of the SMC. That order was not been challenged till today. Only my recommendation, but that has become infectious because already I am been appointed. Although there is a stay order operating, I am unable to take the charge, my lord. But that's why this honorable court said specific on that point to give a affidavit. Because in respect of fishery, your lordship kindly see, sometime one fishery will travel through 3 districts. That's why in respect of fishery, my lord, neighborhood question is there. Within the 5 kilometer radius, it should be the neighborhood. So in that way, in case the respect of fishery, it is, my lord, defined. But in respect of, my lord, here in school, my lord,
That is not been defined locally. Even my RTI reply also, that inspector of school and the inspector of school as well as my director also stated that inspector of school state, my lord, that there is no any specific gov guidelines rules stopping the person from a district from became the president as person of a district of to become a president, vice president of a high school situated in another district. The candidate of president, vice president of the assembly high school should be a local person. So there is no bar. That is the inspector of school, my lord, RTI reply. And my lord, director reply is that in the above mentioned the government notification, there is no specific explanation to the word local. So if I go by this, my lord, the guidelines. So my lord, there is no bar. There is no bar that they meant from another district.
Where is that guideline?
Guideline page 27, my lord.
27, yes.
Page 27 and the 11th portion is page 28, my lord. The first clause, my lord. Very first clause. So that's why, my lord, to define to solve the problem, my lord, there is specific direction to the respondent authority, my lord, particularly government respondent, to define this. Once for all, it will be solved, my lord. But they have not filed affidavit till today. But as a result, my lord, although I was appointed, my lord, his order has not been challenged, but I am unable to take charge, my lord.
Now, without that affidavit, can we dispose of this petition?
My lord, no, but they have not. If they say that there is no bar, but inspector said, my lord, but director says that if there is no bar to appoint a person from another district within that area, he should be from that area as per the guidelines.
No, the director has already filed one affidavit.
My lord, thereafter, this honorable court asked them to file an affidavit clarifying position.
Where is that order?
My lord, the order dated, my lord, 29/11/23 and order dated 9/2/24. And kindly see the page, my lord.
Inspector school, inspector school.
The other order dated, first one.
Other order 9/2/2024.
No, the first one.
First one is, my lord, 29/11/2023.
No, was there any direction to file a affidavit?
No, thereafter, no affidavit filed, my lord.
No. Was there any direction to file an affidavit on this point by the respondent number 6?
No, respondent number 6 is the private respondent.
Respondent also is the private respondent, my lord.
No. This respondent authority.
Yes, your lordship.
Where? 29/11/2023.
9/2/2024, as well as order dated 29/11/2020.
You come to order
Yes, my
dated
lord.
29/11/2024.
9/2, order dated 9/2, my lord. Mr. U. Sharma, learned standing counsel, is granted 2 weeks time to file a appropriate application clarifying the meaning of in about the criteria one local application. That is order dated my lord 9/2/2024. Last but one paragraph.
Madam, you file the affidavit, you obtain instruction.
Lordship will obtain. Lordship, in page 80, your lordship, in the affidavit that we had filed, your lordship. there
Yes,
says
80.
80, your lordship. Eight.
Yes.
80, lordship, we have stated the respondent number 6 is a resident of village Dampur, Alongar from Pokraj.
Paragraph number.
Lordship is paragraph 4, your paragraph 4, page 80, your lordship. He is a resident of Pokraj, the BTR area, your lordship. And this school is in Dhubri district, your lordship.
It is not dispute, my lord. It is a correct position.
And
It is not dispute.
and the rules, in the rules, the composition that is required is that he has to be a local educated citizen, your lordship.
My lord, kindly see the page number 95, my lord. Inspector of school said that, my lord, no any person, no any power to recommend or select any person as the president of SNDC high school outside the district, my lord. Question is not the, my lord, 800. It can be 200, it can be 800, it can be, my lord, more than 800.
Page number
Page number 95, my lord.
95.
95, running page.
Uh,
This is the RTI reply, my lord.
95.
95, last page, in fact. my lord. That is why your lordship affidavit is required, my lord. Definition of local law.
No, where is that guideline?
Guideline is page, my lord, in my petition, my lord. Page, my lord, 27 starting, my lord. Annexer,
27.
my lord. Annexer 5.
No, whether after going to the
And
page
local,
number 27.
28 is the operative part, my lord.
Yes.
28, my lord, is a table, my lord, close 1. One local educated reputed citizen having no political career, my lord. Here the question is the, my lord.
No. Whether going by this serial number 1.
My lord.
It can be said that other district citizen from other district cannot be the resident of the school management committee.
Yes, your lordship. My lord, in page 95. Page 95, inspector of school, my lord.
No, if this page number 28 is the guideline.
My lord.
After going through the same, can this as an inference can be drawn up?
Yes, lordship. My lord, in every respect, my lord, deputy commissioner follow the district jurisdiction. He cannot go beyond his jurisdiction, my lord. And particularly, my lord, my lord, respondent number 6 in this case, my lord, but he is residing outside of district, was appointed as, my lord, recommended as president of this, my lord, body, my lord. Otherwise, my lord, deputy commissioner follow the district jurisdiction, and inspector of school is the, my lord, jurisdiction of this school. So, my lord, local means person within the jurisdiction of the inspector of school or within the district, my lord, not beyond the district. It is no matter that the, my lord, outside the candidate who is residing 800 or 100 or more than 800.
While arriving at such a finding, the inspector of school referred to this page number 27 and 28.
My lord.
After going through the page number 27 and 28, can such an inference be drawn?
Yes, yes, because this interpretation will apply in other cases also. So that is why in earlier occasion, my lord, the honorable court, my lord, asked to clarify the local.
Madam, immediately after reopening, you
My
file
lord.
the affidavit.
My lord, let them silent positively because my lord, the last several occasion, my lord, they have failed, my lord. As a result, school is suffering, my lord. Because
Yes.
the school is running without my lord managing committee, and managing committee in a government school, why it is required? Because without a managing committee, my lord, they are only look after the development work of the school. Now, since there is no my lord governing, my lord, that my school development work of the school is being stopped, my lord.
Agree. Pardon me, sir.
M. Islam.
And Islam learned.
M.
And Islam learned counsel for the petitioner and Mr. DJ Monto, learned senior counsel assisted by Ms. So-and-so, Mr. So-and-so for respondent number 6. And Ms. Musahari for respondent number, respondent in secondary education department. Ms. Musahari submits that she may be granted some more time to obtain instruction and to file an affidavit. Pursuant to order of this court 9/2/2024. 9/2/2024. There is accordingly allowed. List the matter for takes on them.
28 April.
It is made clear that no further opportunity will be afforded to Ms. Mosari to file the affidavit in this regard.
Highly obliged.
Item number 17, matters for orders.
Made, please, Lord. My lord, I'm not a respondent, I'm for the respondents here, my lord. My lord, what has happened, the opposite party, the respondent, Abdul Ghani, he expired, my lord. So I am the legal heirs, because this has to be, my lord, substituted. He died on 23, my lord, 3/2/2020, my lord.
You are for the appellant.
Not opposite party respondent, my lord.
Respondent. Okay.
Abdul Ghani, my lord, because
But the appellant is absent.
they are not, because what has happened, the legal heirs of both these, they have substituted the legal heirs, what I get from the records. But they have not substituted, as my lord, I being a lawyer, my lord, of legal heirs, my lord, I just inform to the court as per the order 22 rule 10A of CPC, my lord, expired, my lord. Abdul Ghani, this respondent has died on 3/2/2020, my lord.
Three to 2020.
My lord, yes, my lord.
None appears for the appellant on call. However, Mr. Bora learned.
Sorry, my lord, 5/2/2020, my lord.
5/2.
5/2/2020, my lord.
Okay. Learned senior counsel assisted by Mr. So-and-so, appearing on behalf of the legal heirs of the sole respondent, namely one respondent.
Yes, my lord. What, my lord? Abdul Ghani, my lord.
Abdul Ghani,
who expired?
suffered demise on 5/2/2020.
My lord.
2020. And submits that there is a requirement for implementing the legal heirs. But the appellant remain absent today.
Because of this thing, that suit is also abated, my lord.
Yes, on next date we will take a.
My lord.
On next date we will take a call on that.
My lord, my lord.
List the matter on
2nd May.
2nd May. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
My lord. Oblige, my lord.
Item 18.
The revision petition has been amended, Your Honor, in view of the order dated 23/2025, in IA, which has been disposed of on 23/2025, 3685. We have inserted the legal heirs of the respondent number 4, defendant number 4. But the thing is that no notice has been issued regarding new new legal heir which has been inserted in the civil division petition.
So notice are to be issued.
Yes,
Now,
notice has not been served upon the newly implemented this legal heirs of the respondent number 4.
My lord, they have in 2015 notices issued except the respondent number 1, 2, 3, and 4 onwards. They did not appear last 10 years. Then lordship says, I have no objection and allowed for substitution, anything. So my lord, hear it, because 10 years, lordship last. Notice is not necessary because they did not turn up. Earlier notice was issued to this respondent 4 onwards. Then how long time I'll be here? I have no space even and date. Last 2015 cases heading till today. I'm suffering.
This formality are to be observed, no? Otherwise, tomorrow
Already.
come and says that without hearing him, we have passed the order.
Absolutely, man. There is the already order is there, substituted. And if it is he is in the game, then automatically it is.
No,
Is appeal continue?
you tell me, are we not supposed to issue notice to the newly?
I think not necessary, my lord, because they did not appear last 10 years.
Or you are representing them.
No, I'm not representing those.
Then
The things is that, my lord, if the notice is issued, again 10 years, then who will suffer? It is a partition case. They lost the title suit. They filed this appeal 2014. Then he has come against the order, interim order regarding the substitution of respondent number 1. I am the son of the respondent number 1. See this situation.
no,
And this
maybe.
is my appraisal before this one.
Maybe, but without issuing notice and without affording an opportunity of being heard to the other side, can we dispose of the petition?
I think, my lord, it is, lordship is correct. Otherwise, my lord, kindly see 10 years. 10 years,
Maybe
right?
I will permit him to cause a service of notice by dusting wood also.
Yes, my lord, a short date may be given because it is Rongia.
Ramya.
Rongia. And, all the parties are nearby this
Okay.
petitioner.
Heard Mr. Borwa, learned counsel for the petitioner, and also heard Mr. Sidwal, learned.
Respondent number 1, 2, 3.
Respondent number 1, 2, 3. Mr. Borwa submits that pursuant to order of this court dated 28/3/2025, he has already substituted the legal heirs of respondent number 4.
Yes, lordship.
Respondent number 4 as
4A, 4B,
4A, 4B, 4C, and 4D. And he has also submitted this amended cost title.
Yes, already amended the cost title.
And also submitted an amended cost title. Now notice has to be issued to the aforementioned respondents. Accordingly, it is provided that state upon respondent number. No, accordingly, it is provided that notice be issued to the respondent number 4A, 4B, 4C, and 4D by registered post with AD and also by usual process within a week from today. Dusting wood is also permitted. Place the matter after
30th of April.
It is not, it's too short.
No. 10 years without any meaning.
Okay.
Without any meaning.
Okay, you try it.
Yes, I will try it.
30th April, March of next.
Yes, yes. Will resume after 5 minutes.
Lordship. Coming item number 8.
On the last occasion, we were asked to place the updated instructions, Your Lordship.
You received.
Lordship,
Let's see.
So the direction was to obtain up to that extraction.
Lordship. Lordship, the progress is because when the proposal was sent by the director to the government, your lordship, government had asked for certain queries, your lordship. The query was whether there is any post creation order, your lordship. In reply to that, the IS had submitted that there is no post creation order. However, they have shown the vacancies, your lordship. They are vacant posts in which the petitioner can be adjusted, your lordship. So now, lordship, the government should look into the matter on that basis, your lordship. So now on this basis, that since there is no post creation order, however, there are vacancies. The government will look into it, your lordship, whether
Pardon?
the government will now look into it, whether he can be adjusted in those vacant posts or not, your lordship. Because there is no post creation order.
Then how the advertisement was published?
Lord, advertisement, lordship, there were posts at that time, your lordship. But due to
What happened to
non-retention,
those posts?
lordship, due to non-retention of his post, where he was supposed to be appointed, he was not appointed. And thereafter, there were actually there were 3 candidates who were selected, your lordship, who have already been appointed on the basis of your lordship, High Court's order, your lordship. And the other person, the petitioner, he had not approached the court, for which he was left out, your lordship.
No, now you tell me, is it the extent of the respondent authorities that the petitioner will be adjusted against the vacant post?
Not sure, the stand of the director is that he can be adjusted. So now we have sent a proposal in that way, Your Lordship. Now the government will have to decide whether he can be adjusted or not, Your Lordship. Because now, Your Lordship, grade 3 employees, their appointments are made through commission, Your Lordship.
Great.
Grade 4, Your Lordship, grade 4 employee, they are made through commission. So that is a different.
Maybe now he may be over his now.
So in fact, in the last instruction that we had placed is that the vacant post that we have shown, that has not been shown in the advertisement. So the post is vacant. The Lordship will give us, Lordship, some time, let the government decide, Your Lordship.
Let it come on, Lordship, after vacation. And
After vacation, Your Lordship.
he may,
After vacation.
he may obtain.
Heard, Mr. M. Khan learned for the petitioner and Ms. Musari for respondent authority. Ms. Musari has produced some documents before the court, which indicates that some communication are going on between the authorities. And Ms. Musari further submits that there is no post creation order in respect of the present petitioner. However, some posts are lying vacant and the respondent authorities are contemplating to adjust the petitioner against the said vacant post. And as such, he may be granted some time to obtain further necessary inspection. There is accordingly allowed this shall be the matter of the due vacation. The documents produced before the court today shall be part of the record.
The date will be given us.
7th May.
As part
Item
of-
19.
As part of that.
Your Lordship, on the last date, we were directed to take fresh steps upon respondent number 1 to 6. And as per the office note dated 11th March 2025, R1 to R6 are duly represented by filing Wakalatnama, and the LCR has also been received, Your Lordship. The appeal was admitted earlier, so Your Lordship, the matter may be taken up for final hearing.
Yes, sir.
Hearing on behalf of respondent number 7 and 8.
7 and 8.
Your Lordship, there is one number 1 to 6.
1 to
1 to 6.
1 to 6. So matter is ready for hearing.
Yes, Your Lordship.
We are willing to file an affidavit on behalf of respondent number 7 and 8.
Okay, we will fix the matter for hearing. In the meantime, you file the affidavit. Both the parties are represented by their English counsel. It is submitted at the bar that that service has already been completed and the matter is ready for LCR has also been received and the matter is ready for hearing. It's a receipt. Hello. Matter is ready for hearing. Accordingly, it is provided that recessal is the matter for hearing in usual course.
Yes, Your Lordship.
They did not provide a copy of memo of appeal, Your Lordship. They may be directed to provide.
Partition copy of memo of appeal.
Yes, Your Lordship.
The learned counsel for the respondent number 7 and 8 submits that she will file affidavit in opposition in this petition. In this appeal, there is allowed. Before the next date of hearing, the counsel for the respondent number 7 and 8 may file the affidavit.
Item 20.
May it please your lordship.
Lordship, we were directed to take steps by way of dusty upon respondent number 6, Lordship. We have annexed our affidavit. That is in flat X, Lordship. So here the service is complete and LCR also been received.
Okay. Same order. Both the parties are represented by their MD. Is submitted at the bar that the matter is ready for hearing. As the service has already been completed and the LCR has also been received. Accordingly, it is provided that recital is the matter for hearing in usual course.
Obliged, Lordship.
21.
I asked for condemnation of delay of 38 days
3459.
for filing
Sab নহয়নি?
regular first appeal.
লাগিব submission na copy.
Mr. Monto, any
My lord, I am actually delayed. Normally, I am not I have no objection, but I am representing only my lord 3, 4, 5, and 9. What about others, my lord? I am only 3, 4, 5, and 9.
Okay. Mr. Monto, you are for
3, 4, 5, and 9.
right. Personal. One respondent, respondent number 6 died on 1/7/2015. And respondent number 7, he left for Silsor. So, you have to take necessary step, Mr. Bora.
Madam?
Heard Mr. L.K. Bora, learned counsel for the applicant, and Mr. Monto, learned counsel for the respondent number 3, 4, 5, and 9. Office note dated 22nd of October 2024 indicates that service in respect of respondent number 1, 2, 2, 10, 11, 12, 13, 14, 15, and 16 completed. And the said office note also indicates that respondent number 6 suffered demise on 1/7/2015. Accordingly, it is provided that the learned counsel for the appellant shall take necessary step for filing impletement for impleting the legal heirs of the respondent number 6. And respondent number 7, as per office note, moved to Silsor along with the entire family. Mr. Bora shall obtain instruction and also take press step upon respondent number 7. And respondent number 8 refused to accept the notice. Yes. There is a discrepancy in his name in the notice issued to him. Mr. Bora shall obtain necessary instruction and take press step upon respondent number 8. List the matter after 4 weeks.
I did instead. Sorry, I have to go through the office note, but sorry, I'll go through it.
22 and 23.
Right, Mr. Lashes. My lord, kindly take the item number 23, my lord, which is the appeal filed by the insurance company, my lord. Actual fact, my lord, the mother of the petitioner, appellant, my lord, died in the year 2015. Thereafter, judgment was pronounced in the year 2019. And in 2019, the insurance has filed the appeal, my lord, 514, my lord, stating that, my lord, the mother was a pillion rider, so she is not a third party, my lord. This is the only ground, my lord. And and this Honorable Court only issued notice, my lord, not state the judgment till date, my lord. And they have not paid any amount. And the next, my lord, appeal, my lord, 592 filed by us, my lord, with a prayer to enhance the award, my lord. And in this case, my lord, 592, although the insurance company has filed the appeal number 514, but as per office note shows, my lord, the AD not returned after service in item number 22, my lord. So, my lord, and the other party are, my lord, only formal party, my lord, in 592 appeal, my lord. And my lord, kindly take the appeal 514, my lord. Item 23, the ground of the appeal, my lord.
You are for respondent number?
I mean, item number 23.
In
No, in
514, 1 and 2.
In 23, you are for the appellant.
Yes, they are appealing.
Yes.
But in item number 22,
you are-
Lordship, we are not.
No,
there
no,
at all.
no. You are for respondent number?
In item 23,
Yeah.
1 and 2,
1 and 2.
the claimant, my lord. And the others are the, my lord, formal
Three,
party.
3 and 5. 4
Yes.
has already been struck off.
Yes.
3 and 5?
Service is complete, Lord.
Service is complete in item 23, my lord.
And
When this
healthcare
is service
also-
completed.
Yes, my lord.
Office note, Lordship, 6922. Regarding service.
Okay. R5. In MSA case number 590, MSA appeal number 592 of 2019, how many respondents are there?
Here, my lord, four respondent, three respondents are there.
Three.
Yes.
And you are appearing for?
I am
Oh, appellants.
appellant.
1 and 2.
Yes, my
There are
lord,
2 appellants.
two appellant.
Then Mr. Sharma for respondent number 1.
Yes.
So in item number 22, in item number 22, I am not present, Lordship. I am only in item number 23.
Handicap not written as per office note, my lord.
Because we have not been given any instruction to appear in that case. That's why our
But-
Wakatama is also not there, Lordship.
That is why my lord, I prefer take the appeal number 514, my lord, because my lord, the appeal is pending since 2019 and the matter instituted in the year 2015. my lord. And
The
Our
problem
Lordship,
is
if
that,
you give us a copy of the appeal memo in item number 22, we can obtain the instruction and accordingly we can appear and the case may be fixed for hearing because it is already fixed on hearing stage. Everything is ready, Lordship.
no, but regarding this respondent number 2 and 3 then?
2 and 3, my lord, in item number 22, my lord. It, they are, my lord, formal party, my lord, only. They are not required, my lord. They are formal party, my lord.
Who is appearing for no, AA
Uh,
Ahmed? Who is
two-
AA Ahmed?
For respondent number 2 is already, someone has filed Kalatnama. But 3 is a formal party, my lord.
Not necessary.
Not necessary, because, my lord, initially, respondent number 3 was the owner of the vehicle, my lord. Subsequently,
Then
the
who will strike of his name? No, respondent number T is 2 is the owner of the vehicle.
yes, my lord. Now, that is the,
Respondent number 3 is the owner of the motorcycle.
yes. Only, my lord, initially, the respondent number 3 was the owner as well as the insured.
Okay, one by one, you take down in item number 22. Third, Mr.
M. Hussain.
M. Hussain, learned counsel for the appellants. None appears for the respondent number 2. Though the name of one counsel is reflected in the cause list. Service report in respect of respondent number 1 and 3 is awaited. The learned counsel for the appellant submits that respondent number 3 is a formal party. And his name may be struck up from the array of this appeal. And accordingly, taking note of the submission of learned counsel for the appellant, it is provided that the name of respondent number 3 be struck off from the array of this appeal at the cost and risks of the appellants. Mr. Sharma, learned counsel, appearing in item number 23 for the appellant, submits that In this appeal, he has no instruction to appear on behalf of respondent number one. However, he submits that he may be furnished with a copy of the memo of appeal, and on next date, he will obtain necessary instruction in respect of appearance. Accordingly, it is provided that learned counsel for the appellant shall furnish a copy of the memo of appeal to Mr. Sharma during the course of the day. In item number 23, you take down. Both the parties are represented by their engaged counsel. It is submitted at the bar that the service has already been completed and the LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that SSL lists the matter for hearing in usual course.
My lord.
Along with MSC appeal number 592 of 2019.
My lord, 2015 matter, my lord, if my lord.
Appeal is of
directed-
2019.
19, appeal is 19. Accident occur in the year 2015, my lord. If my lord directed to list the usual course, my lord, it will take further more time. So, my lord, date may be fixed, my lord.
Okay, in the second week of May.
Second week of license.
27.
It pleases your lordship. Lordship, as per the office note dated 1912, my lord. The respondent number one has appeared, man. And respondent number three has expired, man. And regarding the service of respondent number two, someone has accepted notice on his behalf, my lord.
No, as per office note. No such person is
No,
there.
that is regarding registered post, my lord.
Hmm.
Regarding usual process below. The foot of the page, my lord.
No, that cannot be accepted.
Yes. Best steps maybe.
Part Mr.
A decal.
A data learned counsel for the petitioner and Mr. A Hussain for respondent number one. A Hussain for learned counsel for the respondent number one. Office note dated 19/12/2022 indicates that respondent number three suffered demise. The learned counsel for the appellant. The petitioner shall take necessary steps for completing the legal heirs of the respondent number three. Office note, side office note also indicates that as per postal remark in respect of service of notice upon respondent number two, no such person is available. And as per service report by usual process, it is stated that process server's report indicates that someone else received the notice on behalf of respondent number two. In view of above, it is provided that learned counsel for the petitioner shall take first step upon respondent number two, obtaining necessary instruction from the petitioner. List the matter after 4 weeks.
28.
Please, your lord. My lord, as per office note dated 13/3/25, my lord. Respondent number three is served. Though at the below, it is written no ID card or unserved notice of R2 and 3 has arrived as yet. But my lord, kindly see R3 notice given. Notice was received with seal and signature by an employee of the Brahmaputra Valley Fertilizer Corporation. So notice is served and there is a report of the Jari Karak, my lord.
How many respondents are there?
3, my lord. One
Three.
already served, State Bank already served. 2, it is written that the respondent number 2 has shifted to some other place. So we have to take instruction on that.
Okay. Third, Mr.
SK Chakraborty.
SK Chakraborty, learned counsel for the applicant. Office note dated 13/3/2025 indicates that notice upon respondent number 3 has already been served. Said office note also indicates that respondent number 2 is no longer available in the address furnished and shifted to somewhere else. The learned counsel for the applicant submits that he may be granted some time to obtain necessary instruction and to take decisive upon respondent number 2. Here is allowed. This is the matter after 4 weeks. Step, Mr. Chakraborty, learned counsel for the applicant shall take step after obtaining necessary instruction within a period of 1 week from today.
Yes.
Place the matter after 4 weeks.
Obliged.
29.
Helen? No.
I'm the respondent. My lord, respondent number 6, 7 and 1.
Expired.
They are expired since long.
None appears for the applicant on call. However, Mr. SK Coles, learned counsel for the respondent number 2, 5, 6, 8, 9, and 10 present.
My lord, yes, opposite party number 1 died August 2023.
It is already recorded.
And respondent number 6 died 20 years ago.
That is also recorded.
Recorded.
Date is not recorded, but it is
Date-
recorded that
Exact date, I have no information also.
Mr. SK Coles, learned counsel for the respondent submits that respondent number 1 suffered demise in the month of August 2023. And respondent number 6 suffered demise 20 years back. And respondent number 7
12 years back.
suffered demise about 12 years back. List the matter after 2 weeks. In the event of subsequent non-representation of the applicant, appropriate orders shall follow.
30 and 31.
Yes.
May it please your lordship. In this matter, we have filed one additional affidavit, lordship. Requisition was given but not yet received in the records. Lordship may be taken after some time or at 2, lordship.
2 o'clock, my lord. At 2 o'clock.
Okay.
Matters matter fine.
Okay, at 2 p.m.
Lordship.
33.
Let me bring for the response. Let me court order का अमूल mention करना मैं दे दूँगा.
So both the parties are represented.
Yes, both the parties are it.
Record has been received. So when can it be fixed?
In the month of June, if possible.
June.
June, on 19th or 20th June, because I am coming from Delhi and my mother is not well.
Okay.
If
Sir,
possible.
your good name, please.
Sachit Sharma.
Learned counsel for the appellant, and sir.
A Kabra.
A.
Kabra.
A. Cabra, learned counsel for the respondent. It is submitted at the bar that the LCR has already been received and the matter is ready for hearing. But it appears from the record that the matter is yet to be admitted. Accordingly, it is provided that no, the matter be admitted for hearing. And since service has already been completed and the record has already been received, SSL list the matter for hearing in the month of on
19th June. 19th or 20th June, any.
20.
20.
20.
19th of June is okay. Highly agree.
24.
Please, your lord. Lord, I am appearing for the respondent wife. Her transfer petition, my lord, civil. There is a divorce proceeding pending, my lord, between both the parties.
you are for respondent
Respondent wife, my lord.
in this petition.
My lordship.
Who is for the petitioner?
I don't know. Proceeding is going on.
Yes, sir. Proceeding is?
Going on at Udalguri district. And the respondent.
Who filed the petition?
This petition has been filed by the husband, my lord.
Okay. You are for the wife.
I am for the wife. I have preferred a divorce proceeding before, my lord, Udalguri court, my lord. And that is pending.
And
Now
petitioner
is seeking to transfer that proceeding from Udalguri to Guwahati, my lord.
Okay. By order. The matter was mentioned by the petitioner,
Mentioned.
but the petitioner none appears for the petitioner on call. However, Mr. Das, learned counsel for the respondent present, list the matter. That what is says it is pending there.
The evidence is going on, my lord.
Evidence
Not statement. Evidence
Not
is going on.
Let it go.
This
List the matter after 2 weeks. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
35.
My lord, this is a matter. Look,
This I is for what purpose?
it is stay for further proceeding. Actually, what is the matter? It is a civil suit was filed, partition suit. Already partition suit, judgment is there, but final decree has not been prepared. During that period, a will has been executed by the testator, one of the shareholder. And then a probate petition filed before the Honorable FTC for Amrupet Guwahati. And then the civil proceeding stayed till dispose of the probate proceeding. And probate proceeding has already been in favor of the respondent plaintiff in the trial court. And subsequently, the original partition suit kept in abeyance till deciding of the probate proceeding. Now, probate proceeding has completed, but civil suit is continuing. So now, it's a subject matter of the both the proceeding are same subject matter. That's why the civil suit proceeding is going on to prepare final decree. Now, the probate proceeding is under fraud. And during illness, it was forcefully executed. Now it is appeal, testamentary appeal against the will, one of the shareholder. Now my humble submission, record has already been received by the general court from the probate proceeding title suit. Till hearing of the further proceeding of the impugn order may be stayed. This is my.
Yes, what is your submission?
Lordship, in this council is on his, let it come, Lordship.
Who is leading counsel?
An alarm,
Pardon?
an alarm, Lordship.
Okay.
He's here, Lordship, and allow me to call him, Lordship. He's here.
Yes, I call it. Wait, Mr. Bora.
435 and 36, Lordship. 36 saying.
Pardon?
36.
36?
Same.
Yes, Lordship. I am here for the applicancy order. Our injunction matter is there. In the last time also, they had taken the adjournment order. It should be taken up at 2 positively. At 2 positively.
No, we can take it back.
Yes.
Fine.
Our injunction matter is there, Lord.
Can be taken back now, Lordship. It can be taken back now, Lordship.
36.
36 and 30.
Fine.
Allow me to contact him.
Fine.
Okay.
38. 38.
It is a petition for implication of the legal error, but they had not submitted legal error certificate. My lord, legal error certificate, how it can be considered?
Delay has already, as my lord has allowed our delay application, my lord. 3444. Delay already condoned on 19/3, my lord. 19/3/2025. IA disposed.
Legal error certificate.
No, no, legal है नहीं।
Legal error certificate नहीं।
नहीं, legal है क्या लगा? Substitution.
कोई नहीं है, legal error।
Substitution.
Substitution.
Today's fix for substitution of the legal heirs, my lord, 3446, sorry, 3445, IA. Delay already condoned, your lordship has already condoned the delay, my lord, may substitute the legal heirs. 3445.
For substitution, legal error certificate is required.
So how many legal heirs are there?
3, my lord.
3.
Page 4, my lord, paragraph 2.
Sitting aside abatement.
Page 4 of the IA, my
So
lord.
you have the legal heir certificate?
No, my lord.
No.
No, I have not annexed. Is it necessary, my lord?
No, unless they have disputed, it is not necessary.
We have never filed, my lord. as such.
Earlier.
Earlier, never filed.
Heard Mr. Chakraborty, learned counsel for the applicant, and Mr. Sharma for the respondent. This application under order 22 rule 3 of the Code of Civil Procedure is prepared by the applicant for substitution of the names of appellant number 1, Sri Hariprasad Sharma in RSA number 174 of 2011, with his legal heirs. Mr. Chakraborty, learned counsel for the applicant, submits that appellant number 1, Hariprasad Sharma, died on when he died?
29/3/2020.
29/3/2020, and what petition was allowed earlier?
Condemnation petition. Delay for
That, delay condemnation petition has already been allowed by this court, and as such, there is a requirement for impeding the 3 legal heirs, namely Srimati Beena Devi as A1, Milan Sharma as 1A, Srimati Beena Devi, 1B, Sri Milan Sharma, and 1C, Heman Sharma. In the RSA number 174 F and 174 of 2011. So, Mr. Sharma, any objection you have?
My objection is they have to file a legal error survey. How we know that they are a legal error of the disease defendant, my lord? They have to file a legal, that is a procedure. Where court is
No,
not
is it
satisfied that
provided
they are
in
the
the,
legal error. There
is
may
it
be other
provided in
legal
the,
errors or they may not be legal errors.
no,
That
is
a
it
challenge.
provided in the CBC?
On affidavit matter, we have filed that we are the only legal errors. See, how can there be more or less? It is by swearing an affidavit, the applicants have filed the IA. And we have stated that we are the three legal heirs.
Affidavit is
Okay,
different.
at the time of hearing, we will take note of the same thing. It is, it says, we will allow the petition. Having heard the submission of learned counsel for both the parties, this court is inclined to allow this petition. The name of Srimati Beena Devi, Sri Milan Sharma, and Sri Heman Sharma be pleaded as legal heirs of the appellant as A1A, no, 1A, 1B, and 1C. In terms of above, this IA stands closed.
And 3446 for setting aside abatement. Since my lord has already condoned the delay and substituted this.
What
may
are
be
the
set
abatement
aside.
orders passed to be set aside? What are the abatement orders passed in the record to set aside? I have no abatement orders passed.
No, there was a direction for filing such an application, and
No, my
therefore
lord,
he
delay I
filed.
have already explained in this. If lordship wants, delay I have already explained.
Heard Mr. S.K. Sokurati, learned counsel for the applicant, and also heard Mr. Sharma for the respondent. 3446.
My lord,
This interlocutory application is preferred by the applicant for setting aside the abatement.
as against
As
appellant number
against
one.
the appellant number one.
One, my lord.
Mr. Chakraborty, learned counsel for the applicant submits that appellant number one suffered demise
On
on
29,
29 3
2020.
2020, and his legal heirs have already been impleted in the RSA number 174 of 2011. And as such, there is a requirement for setting aside the abatement against the appellant number one. Taking note of the submission of learned counsel for both the parties, this court is inclined to set aside the abatement as against appellant number one.
We will not allow the legal petition that may be fixed for hearing because it is a case of 2011, my lord.
Okay.
Yes, ma'am.
Mr. Security learned counsel for the appellant shall file amended costate.
Yes, ma'am.
Within a period of
After view vacation, my lord.
okay. After view immediately after view
Yes,
vacation.
ma'am.
And shall list the matter for hearing on
After summer vacation, my lord.
In the first week of June.
Too long,
Huh?
my lord, after
In the first week of June.
first week of May.
Oh, okay, okay.
first week of May, not possible.
June.
June.
On 3rd June.
My lord. How like?
Good night.
May I please, lordship? I am sorry for interruption. My lord, my matter was 34, my lord. And my lord, my representation may be recorded. 34.
So you knows that your item number is 34.
My lord. My lord, I was in another.
Where?
Statement. In court number 17.
7.
70.
70.
Yes.
Okay, we will see. We will check it in the computer.
Yes, ma'am. There,
If
my
it is
matter
there,
was
only
35.
then we will record your presence.
My lord.
Otherwise, not. Okay.
Yes, my lord, yes. Obliged. We are supposed to file our objection. We are filing the objection during the course of the hearing. Okay, we have the matter on Friday. Okay. In this case.
Today,
Yes, Lord.
you are going to file today?
Yes, Lord.
Okay.
Lordship, on the last occasion also I said that there is some grave urgency, Lordship.
Okay.
Lordship, regarding this matter, I have a criminal case listed on 11th of this month at Calcutta. So from 28 to, they are seeking adjournments. Today's 40th day, they have not filed the objection.
And Lordship may take up the matter and take it up.
Lordship, this is a matter I am seeking
In
and
the meantime, I will file our objection and we will demonstrate that this
No,
petition is not.
unless and until your objection is placed on record, how can we hear them?
Because I will.
So is there any urgency?
there is an urgency. This is the last chance and the matter may be fixed on Friday.
We'll check it up on 21st of April.
Lordship, that will be very late. This Friday, Lordship. Friday.
Friday, not possible.
Because on that day, I am having a criminal case in Calcutta also.
Maybe.
Lordship, if the case is listed after vacations, the
21st.
Lordship, my prayer will be infructuous. Actually,
Lordship,
actually,
I will
demonstrate Lordship, this petition is not maintainable because suppression of PS here. So the same prayer he has filed an petition which has been dismissed by this honorable court, Lordship, being not maintainable, wherein the same prayer is there.
No. This prayer is for seeking relief, monetary relief, Lordship.
Petition, Lordship.
Lordship, this is monetary relief.
Okay, we'll hear on 21st.
Yes.
Heard, Mr.
S. Nag.
S. Nag, learned counsel for the applicant, and also heard Mr.
K. Kolita,
K. Kolita, learned counsel for the opposite party number 4 and 5.
4 and 5.
Mr. Kolita submits that he will be filing his objection during the course of the day and place for listing the matter after review vacation. There is accordingly allowed. Places shall list the matter on 31st.
And 40.
Published.
I 329 for the applicant claimant for release of money of 30%. The order is on page 10. Since the concerned appeal has been emitted for hearing, the operation of the judgment and awarded so and so, passed in MC number so and so by the line MC Nagaon shall remain still till disposal of
Was
the
the
appeal.
deposited before the rest of this court?
Yes, I have said.
Yes, any objection?
Yes, Lordship. We have filed objection. Kindly see para 4, 5, and 6 of our objection petition, Lordship. Page number 3, Lordship.
When you have filed the objection?
I received on 17/3/24.
But it is not on record, and office note dated 17/3/25 indicates that objection has not been filed till date.
They have objection that the order of the Learned Tribunal is wrong because they have she was a minor of 17 years, 16 months, and so the as per the Sala Barla case, multiplier 15 is not applicable. This is the objection I have received.
For Lordship, Learned Tribunal of the Nagaon.
No, your affidavit is not before this court. How can I read paragraph number 4? So we will ultimately hear the appeal. Let him withdraw the amount. Heard Mr. S.R. Gogoi, learned counsel for the applicant, and also heard Ms.
P. Sutia.
P.
Sutia.
Sutia, learned counsel for the respondent number 1.
Yes, Lordship.
Respondent opposite party number 1.
Opposite party number 1.
Yes, opposite party number 1. This interlocutory application is prepared by the applicant for allowing him to withdraw. allowing her to withdraw is sum of rupees 4,29,072 rupees, being the 30% of the awarded amount deposited before the registry of this court as per order dated 19/6/2024, passed in IA, indicate C, number 1832 of 2024. The learned counsel for the opposite party number 1 submits that she has filed objection in this application, but the said objection petition is not available on the record. However, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances of the record, this court is inclined to allow this application. The applicant, how many applicants are there?
Only one.
The applicant is allowed to withdraw the sum of rupees 4,29,072 rupees from the registry of this court in terms of this IS close.
Oblige.
The conviction and sentence, a conviction of the appellant under the provisions of the IPC 3067 and 326 are maintained, as well as the conviction and sentencing of the appellant under the Arms Act are maintained. However, the sentence is reduced to 10 years.
Deeply applied.
May I please, Your Lordship? My lord, in this matter, my lord, we have filed one IM, my lord. I am for the respondent 1, 2, 3, and 4, the claimants, applicants, my lord, for the direction to deposit total out of total amount of 50% before this registry, my lord. And I am the wife.
Okay, Mr. Goswami, any objection?
Lordship, in this particular case, we have filed an application for stay along with the appeal. And Lordship, appeal was admitted and Honorable Court has issued the notice at a relevant time, no stay order has been passed. My dispute is in this particular case, originally FIR has been filed regarding 302. FIR has been filed under section 302, Lordship, a murder case. Ultimately, police has filed charge sheet under section 279. And ultimately, Lordship, a person has been acquitted by the trial court, before the trial court. So in this particular, some disputed facts are there, but we will deposit 50% and that may be really subject to bond, Lordship. Because there is a dispute regarding the accident. And total award is 82 lakhs, Lordship. 82 lakhs an odd. Amount is huge, Lordship. We'll deposit 50%, Lordship. Subject to bond, it may be released. Total award, Lordship, will find in the appeal memo. Total award is 82 lakhs 90,605 with interest 9%.
So the Mr. Deka, this application is for depositing the 50%.
50% so that we could.
No,
And
earlier, while
this is
granting
jealous.
stay, there was no order for
No,
depositing.
no. So Lordship may dispose the stay petition directly us to deposit the 50%. And in the application for withdraw or deposit, that may be considered that it will be subject to a bond.
No, you have not yet deposited the amount.
Because stay petition is pending, Lordship. Stay
Yes.
petition was pending, Honorable Court says it will be decided after appearance of the claim.
Lordship may state, my lord, that impending order
Okay.
may be staged.
Subject to deposit of 50%.
Yeah.
Take
Heard, Mr. This stay petition is filed by
Appellant company.
Heard Mr. SK Goswami, learned counsel for the applicant, appellant. And also heard Mr. Teka, learned counsel for the respondent number one.
2, 3, and 4.
Party number 1, 2,
3 and 4.
3, and 4.
2 and 4 are minor daughters, my lord.
Okay. This application is, interlocutory application is prepared by the applicant insurance Oriental Insurance Company Limited. For staying judgment and award dated 1/6/2024, passed by the learned member. Motor accident claim tribunal number 1, Kamrup and Guwahati, in MSC case number 1417 of 2018. Mr. Goswami, learned counsel for the applicant, submits that this court has already admitted the appeal prepared by the applicant as appellant, and the impugned judgment and award so passed by the learned tribunal may be stayed, and the applicant is ready to deposit 50% of the awarded amount before this court, and the same may be allowed to be withdrawn by the respondent, subject however to furnishing a bond. We are taking note of the submission of learned counsel for both the parties. It is provided that impugned judgment and award passed by the learned tribunal in MSC case number 1417 of 2018. They state till disposal of the MSC appeal number 528 of 2024.
The miscase may dispose, that miscase may dispose.
Yes. Okay. In terms of this IAS, that's closed. Then heard Mr. Teka, learned counsel for the applicants. Then also heard Mr. Goswami, learned counsel for the respondent, opposite party. Opposite party number 1. This interlocutory application is prepared by the applicant. Since we have already passed the order, this application.
Yes, my lord,
will take up in
yes,
press,
yes.
Mr.
Yes,
Teka
yes, ma'am.
submits that he will not
In view of the
pass
order
this
passed,
interlocutory
in
application.
view of the order passed in connected stay petition.
Yes.
In view of the order passed in I number 3102 of 2024. According to this, I that's closed.
Yes, my lord.
After depositing the 50%, you may file an application
Yes, my
for
lord.
Within 4 weeks, let's say. Deposit within 4 weeks.
Yes.
within 4 weeks.
Deeply obliged, my lord.
Obliged.
42.
But your lordship, this is an interlocutory application in the second appeal, my lord. The suit was decreed in our favor and on appeal it was reversed. It was a case for specific performance of execution of sale deed. Now at one point of time, my lord, when this appeal was pending, the opposite party, the respondent tried to fill up the land, earth filling was carried on. At that point of time, we filed an application before this honorable court, and this honorable court also passed an order. That order, your lordship will find at page 25.
25 of this IA.
Aye. This is a consent order. Relevant page is page 26. Heard Mr. such and such learned counsel appearing on behalf of the appellant petitioner. Also heard S. the learned counsel appearing on behalf of the respondent opposite parties. Mr. Day, the learned counsel appearing on behalf of the respondent opposite party submits that he has filed a written objection against the present petition today only, and the same has not yet been tagged with the present case records. On the other hand, Mr. Mahmood submits that a copy of the said objection has been received by him, wherein it was specifically mentioned that the art filling work was completed 4 months back from today. In such a situation, the court feels that the further continuation of this petition is not required. Inasmuch as Mr. Day has fairly given, this is very important, Mr. Day has fairly given the undertaking before this court that no further art filling or any such act or acts would be undertaken that may change the nature of the suit plan. Accordingly, this petition was disposed of. But this order was passed in the year 2018, Millard, 2017. Now, Millard, recently, Millard, they have started art filling in this suit land, Millard. Millard, I have again, that your lordship come to page 13. I have given some photographs, Millard. And these led us file an application before your lordship, Millard. From 2017 to 2025, nothing was done, but recently they have started again filling.
At what stage the RSA is pending?
Well, yes, it is at the stage of hearing.
Hearing?
It is admitted, substantial laws framed. No, yeah.
So
Your lordship
since
make it-
2018, the matter is not listed for hearing.
Millard?
Last listed on 29/8/2018.
Since then, Millard is not listed. So it can be hard, Millard. Your lordship can fix the date for hearing. In the meantime, Millard, such orders, the respondent authority may restrain to make any attempt for art filling. At one point of time, they gave an undertaking that they would not carry out in art filling. Now, unfortunately, the respondent counsel is not present before your lordship.
So instead of passing any order in this IA, can we list the matter, list the appeal for final hearing?
Yes, that
Within
can be
a
done, but
certain-
the art filling is going on. That is the problem. And they have started to erecting a boundary wall. This is the vacant land. It was land in possession, land is in their possession. Your lordship can fix the date for hearing, for final hearing, no problem. But the paper book has not been constituted. That is the problem.
Let us fix a very short date. In the meantime, you serve notice. Let the other side appear. And thereafter, we will fix the matter for final hearing, this appeal.
Millard, we have served the copy so far this application is concerned. Copy was served to the council, Millard. This interlocutory application copy. It was served on them.
No, after hearing the other side, we will consider your prayer.
No problem, but if the art filling is carried on, this is the problem. That will be the problem. We thought that he would appear.
Okay. Heard Mr. Dasgupta, learned senior counsel assisted by Mr. So-and-so, learned counsel for the applicant. This interlocutory application. But Mr. Dasgupta, you see, can we invoke this provision at this stage?
At one point of time, that was invoked. The similar application was filed, and we have annexed that application here. Because the council appearing for the respondent gave an undertaking, no order was passed. In such a situation, this court feels that further continuation of the petition is not required, inasmuch as Mr. Day has fairly given the undertaking before the court that no further art filling or any such act or acts would be undertaken. That may be changed the nature. Accordingly, the petition is disposed of.
Wait, who is S then? Whether you serve any copy of this application to Mr. Day? the
Yes, yes, it
counsel?
was served.
Served.
Served, isn't it? Yes, served.
Okay. That's there. People. Have you seen Mr. Day in the court today?
Today, no. Have you seen? I have not seen. Or can it be listed before, day after tomorrow? If your lordship wants to hear him.
Better to hear him.
That's all, no problem. Let the matter listed. Aji ki baat?
To last line.
बुधवार ना?
This application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure, is prepared by the applicant for granting temporary injunction during the pendency of the RSA number 240 of 2017. Mr. Dasgupta, learned counsel for the applicant, submits that the applicant herein has served a copy of this interlocutory application to the learned counsel for the respondent. Then in that view of the matter, it is provided that recessal list the matter day after tomorrow. In the meantime, recessal
Forty-three,
day after tomorrow.
item 43.
None appears for the applicant on call, recessal list the matter after vacation.
44.
May I plead your lordship. Lordship, this appeal has been preferred with a delay of 23 days, lordship. This is listed for the first time. 23.
Mr. Talukdar,
I am for respondent number 1, 2, 3, 4, and 5.
you received the copy?
Lordship.
Lordship,
Any
there are other
objection?
respondents also 6 and 7, lordship.
Any objection in condoning the delay?
No, I have objection.
No
Lordship.
objection.
Respondent 6 and 7 is there. Union of India.
They are opposite party, yes.
Opposite party.
What was the ex parte judge or ex parte judgment, lordship?
Expertise.
Lordship. Against the present.
You served notice then. We'll see. Heard Ms. P. Portasesin, learned counsel for the applicant, and also heard Mr. Talukdar for opposite party number
1, 2, 3, 4, and 5.
1, 2, 3, 4, and 5. This interlocutory application under Section 5 of the Limitation Act is prepared by the applicant for condemnation of delay of 25 days in filing miscellaneous first appeal against judgment and award dated 38/11/20. Judgment and order dated 38/11/2024 passed in EC case number 43 of 2017 by the Learned Employees Compensation Commissioner, Kasar Silsar. Let notice be issued to the respondent number 6 and 7 by registered post with AD and also the usual process. We can have. However, no formal notice is required to be issued to the respondent number 1, 2, 3, 4, and 5. Thus, Mr. Talukdar, learned counsel, entered appearance and received notice. However, extra requisite copy of the petition is furnished to him during the course of the in the matter of the 4 weeks.
Pending items 30 and 31.
May it please your lordship. In this case, lordship, the appellant is the plaintiff, lordship. He filed a suit and thereafter, lordship, the defendant appeared and filed counterclaim claiming, lordship, eviction of the plaintiff. So suit dismissed and counterclaim decreed, lordship. Against that, we have filed one appeal, lordship. In appeal also, suit against this appeal was, lordship, dismissed. Against that, we have filed two regular second appeal. Again, one against dismissal of the suit and one against decreeing of the counterclaim. There is a delay, lordship. So two IA have been filed in both the regular second appeals, and my learned friend has filed objection, lordship. On 24/6, an opportunity was granted to us to file an additional affidavit, lordship, by bringing on record the medical document, lordship. Accordingly, we have filed one additional affidavit yesterday, lordship, that is on record. Running page, lordship, 10 onwards, lordship. Lordship is taking up IS civil number 2262.
Yes.
In this case, we have explained why the delay has been caused, lordship, in para 4, page 5. There is a delay of 392 days, lordship.
Yes, madam, you have filed objection.
Yes, I have, my lord. My lord, earlier, when the petition was moved, the grounds shown by my learned friend seeking condemnation were found to be unsatisfactory, and they were given an opportunity to file a medical document. And yesterday, I was served with a copy of the additional affidavit enclosing the medical document that may be looked into. That is no medical document at all. It is a certificate by an apothecary, village base, my lord.
At page number?
Of the affidavit.
15 vernacular and 14 translated copy, lordship. As we have already taken a ground that we suffered from jaundice and we have taken medicine from one Kabiraj, lordship. Earlier, we have not taken any certificate from him. Later, when the court granted an opportunity to bring medical document, then we approached him that you certified that we have already taken lordship medication under you. Accordingly, he certifies. Normally in jaundice, we normally do not approach doctors, lordship, and more particularly in villages, lordship, they did not go to any doctor, lordship. Lordship, kindly see order dated 24/6. There was a direction given to us to file an affidavit giving further explanation as regards the period post 28/4/2022. As because before that period, lordship, already a exemption is there by Supreme Court. And if there is any medical document, she may be permitted to furnish the same in this matter. So accordingly, we have filed this medical document, lordship.
I am not against that, my lord, because Honorable Supreme Court has given protection up to 28 February 2022. So the previous explanation is not required, my lord, but thereafter, when the COVID ban was lifted, the period of limitation started running. So from 1st of March 2022 till 2023 May, appeal was not filed. And the grounds shown in the petition for condemnation, number one, that he was under the impression that he is a poor man, he will be protected by the appellate court. Is it a ground, is it a sufficient cause, my lord? Secondly, the second ground taken that he is a poor man, he was penniless, so he was unable to come before this honorable court. Those grounds were not could not satisfy this honorable court, so a further opportunity was given that he was not well, he was suffering. So a medical document, my learned friend was directed to file an affidavit enclosing a medical document. that she has done by enclosing a copy of a certificate issued by a village badge apothecary. Decisions are there of this honorable court, my lord, sufficient cause has to be very strong also, because it was a suit was decided and it got decided in favor of a party. So when a further relief is sought by your appeal, and when that is barred, sufficient cause must be shown. Our High Court has this, our home High Court.
No, not necessary, madam, not necessary to refer those decisions. No,
Certificate.
you say when the period of limitation starts here.
That period I have not objected. That period I cannot, because till 20th February 2020, the protection is there. Honorable Supreme Court has given.
No, thereafter. No, when the limitation starts.
Limitation started from 1st of March.
Letter something. Yes. When the judgment was pronounced.
Lordship, and the first appellate court, Lordship.
Yes.
12/2/2020.
12/2/2020.
Yes.
So limitation starts from who is there?
Lordship, 12/2/2020, 3 months.
12/2/2020.
This is 12/05/2020. But in between the exemption has come. 15/3/2020 to 28/2/2020, there was an exemption. 15/3/2020 up to Lordship 28/2/2022. So explanation was sought from 28/2/2022, and in 28/2/2022, and we have filed this case on 5/8/2023, Lordship. So explanation is required from 28/2/2022 to 5/8/2023.
28/2/2022 till
5/8/2023.
So going by this certificate, can it be said that you have explained sufficiently?
Lordship, by this certificate, we approached him in the month of February, Lordship. 4th February 2022. And thereafter, Lordship, 3 months, the person was under his medication, Lordship. Thereafter, though after 3 months I recovered, Lordship, he advised, looking into my physical condition, he advised me to take some more rest, Lordship. But even after 3 months, Lordship, I came to Guwahati in the month of May 2022 and then approached advocate, and thereafter I obtained all the copies, and those already I have mentioned in my IA, Lordship.
This believable, my
Paragraph
year,
5.
For 1 year, he was suffering from jaundice, and this certificate is a manufactured one, because what is his status? No certificate, he's a village badge. And this certificate, that he remembers that in the month of 2022, 2nd February, the petitioner approached him. After 2 years, he has given the certificate. 2024, more than 2 years.
The badge is from the same village, Lord.
On the face of it,
Same village, Lordship. We are the village
not
personnel.
bona fide at all, my lord. Not bona fide.
There was
Is it
no
a medical
manipulation,
certificate?
Lordship. I have not taken any medical document from a certified doctor, Lordship.
1 year.
As because the petitioner approached the Kabira, so we went to him, we explained everything, Lordship. Thereafter, he issued this certificate, Lordship. And I have already, in my IA paragraph 5, I have already stated that I was suffering from jaundice, Lordship. For jaundice,
Even for the sake of argument, if we believe this certificate, then for 3 months you will get relaxation. Then
Lordship.
other period,
Lordship, I have mentioned in my additional affidavit, the May 2022. no? Already we came to Guwahati February 2023. That already I have explained in my paragraph 5 of IA, Lordship. Page 6, your Lordship will find. And that in my additional affidavit, I have explained that paragraph 3, Lordship. Paragraph 3, last part, your Lordship will find. After detection, the base started some treatments and slowly I was getting some relief. From additional affidavit I am reading, Lordship. After about 3 months of the treatment, my condition improved gradually, but having seen my physical weakness, he informed me that I need to take rest for more couple of months and advised to take out boiled food for some months. Accordingly,
you are
I took
reading which paragraph?
additional affidavit, Lordship. Page,
No,
Lordship.
is
Ten.
there any averment in your main petition, main application?
Yes, Lordship, paragraph 5, page 6, Lordship. There I have taken the due to COVID, I am a laborer, Lordship. So there is a condition of the petitioner was also mentioned in my IA, Lordship. Paragraph 5, I have mentioned, page 6, your Lordship got that the applicant begs to state that though he collected some amount and wanted to come to Guwahati in the month of March 2021, but in the meantime, the entire nation again stopped by the second wave of COVID-19, and this time they were badly affected by poverty due to various ailments of the family members. However, the applicant, with the assistance of his relatives, collected some amounts and prepared to apply for the certified copies in the month of January 2022, when the situation was coming to a normal condition. But in the meantime, he was fell ill. Later on, it was detected that he was badly affected by jaundice. Thus, it was not possible for him to travel to anywhere for next 2-3 months due to his health condition. It is not manipulated, Lordship. Already this ground was taken in my IA before Lordship obtaining this certificate. Due to all these anomalies the applicant was facing in his life, he was not able to contest the case in time, but indeed he is the same person who took initiative by filing a suit to protect his only residence, and hence there was no negligence in his part in contesting the case. However, irrespective of all these collected.
No, madam, there is no averment that you have taken treatment from a place coverage.
Lordship, normally on this, normally people took medication under Kabiraj, Lordship.
Where you have mentioned it?
No, Lordship, that was, I have only mentioned that I was badly affected by jaundice, Lordship. Jaundice, normally the bears treated all these. The village people took Lordship treatment under bears normally in these cases. So on this ground only on last occasion on 24/6, this court granted opportunity to the applicant to bring those documents, bringing on record that you have taken medication under whom you bring certificate from him. And Lordship, this the plaintiff, he filed his suit, Lordship, and after delivery of judgment by the trial court, immediately the title appeal was filed, Lordship. There was no Lordship negligence on the part of the applicant in preferring the title.
We are not concerned with that. We are concerned with
Had it been
delay
a case
filing
that
the
Lordship
RSA.
is negligent, he would not have not filed the title appeal in time, Lordship. And in this case, Lordship, there are so many decisions of Supreme Court, Lordship. And this court also. If your Lordship permit, I can rely some of those, Lordship. There are so many.
No, that the
decisions, Lordship.
proposition of law is there, that is
Lordship.
well settled. But whether your ground is sufficient or not, that is to be looked into.
Lordship, after going through these grounds mentioned in my IA, Lordship, that opportunity was granted to bring the medical document, Lordship. And
So, had there been any document issued by any doctor,
Lordship, we have not
then
approached any doctor,
the
Lordship,
matter
so
would have been different. Now, this document, how can we rely upon this?
had it been against that, Lordship, we have obtained a certificate from a doctor, Lordship. That would be a manipulation, Lordship. As because we have not approached any doctor, Lordship. That is true, and the petition applicant approached only the Lordship Kabira, so he brings that document, Lordship.
No, had it been in your main application, then we would have accepted. But no such environment is there that you have undergone treatment under the Kabiras.
Lordship. In jaundice, normally, Lordship, treatment was
No,
taken from
normally,
doctors, Lordship.
forget about normally.
And it
Whether
was-
this document is acceptable or not, that is the question before the court.
That was the document, Lordship, from where I took treatment, Lordship, I have obtained.
Okay, we will hear the matter again after Bihu vacation. Heard Ms. R. Chaudhary, learned counsel for the applicant, and also heard Ms. B. Chaudhary, learned counsel for the respondent. List the matter on 22nd of April for further deliberation.
22nd April.
My lord, 22nd April, I have a personal difficulty, my lord. I have a personal difficulty. 22nd April.
When can we fix?
Any day except 22nd April.
23rd?
25.
23rd,
I don't know.
Wednesday.
That will do. And in the meanwhile, I may file an affidavit also against this additional.
Additional
I may
objection.
file here. I may be allowed to.
Oblige.
For me, I do 35.
As a record already received, trial court record has already received by this office. The matter will fix for hearing. Until then, the further proceeding may be.
There is no question of stay. We are not proceeding further, my lord. If he has come up, my lord, matter may be hard finally. We are no way proceeding further, my lord, with the appeal judgment and order.
So that proceeding is separate proceeding. This proceeding also separate proceeding.
Now, which proceeding has to be stayed?
The trial court proceeding. The impugned judgment and receipt may be stayed.
Already, my lord, in view of pendency of this probate proceeding, my lord, trial court has stayed the proceeding, my lord. Trial court has not been proceeding in the proceeding of partition suit, my lord. So there is no question of stay, my lord. This appeal may kindly be hardly your lordship. Trial court has not been taking any effective steps regarding partition suit, my lord. One partition suit is pending between the parties as well as other legal heirs. That is still there pending, my lord. In view of pendency of this probate proceeding.
That's why I am paid for it.
So, this probate proceeding is this testamentary appeal is ready for hearing.
Ready for hearing, my lord.
Ready for hearing.
We will hear the matter finally.
My lord, my lord.
Till then, the further proceeding of the title suit may not be proceeded. He may be considered, I have no objection.
Trial court has not been proceeding further, my lord.
So trial court has pressurized.
No, it has not been proceeding.
You obtain from order from stay from the Honorable High Court.
Trial court, my lord, had not been proceeding as earlier order also when the probate proceeding was pending. In view of pendency of proceeding, probate proceeding, trial court is not. That order is still there, my lord.
There is no probate proceeding. Appeal is continuing.
No, my lord, this appeal is continuation of the original proceeding, my lord.
That's why till then, till proceeding is stay, then there is no word.
My lord, this matter may kindly be heard, my lord, as matter is ready for hearing, my lord. There is no question of stay, my lord. This is my undertaking before lordship. We are not proceeding with the trial court.
Yes, I want that.
Okay, then we will record your.
Yes.
Artist LK Bora, learned counsel for the applicant, and also artist for learned for the respondent. His application under order 41 rule 5 read with section 151 of the Code of Civil Procedure is preferred by the applicant for staying operation of the impugned judgment dated 10/7/2023 and the decree dated 31/7/2023 passed by the learned additional district judge number 3 FTC Kamrup M at Guwahati in probate suit number 07 of 2019. In connection with Miss probate case number 31 of 2015, by which probate was granted in the name of the respondent, struck plaintiff, and in favor of the performer respondent number 4. Mr. Bora, learned counsel for the applicant submits that the testamentary appeal number 8 of 2023 is pending before this court and the matter is ready for hearing. And till disposal of the appeal, testamentary appeal number 8 of 2023, the impugned judgment and decree dated so and so may be stayed as he is being pressurized by the learned
Civil judge number 3.
Civil judge number 3, FTC Kamrup M at Guwahati.
No, my lord, civil judge number 3, not FTC, my lord. Civil judge senior division number 3, my lord. FTC, my lord, trial court of probate proceeding, my lord.
Okay.
And civil judge senior division number 3 is trial court of partition proceeding, my lord.
The title sheet number 215, 2009.
Where you have mentioned it?
Yes.
No, Mr. Alam, there is pair for staying this proceeding, this impugned judgment,
My lord.
10/7/23.
My lord.
Learned. Who pressurize you?
Civil judge 3.
Civil judge senior
3,
division number
civil judge
3.
3.
Okay.
Where original partition suit
Where the original partition suit is pending.
pending.
Pending or disposed of?
Already judgment passed. Preliminary decree has already been prepared, but final decree yet to be prepared.
It is pending for preparation of final decree. Final decree. On the other hand, Mr. Alam, learned counsel for the respondent, submits that the learned trial court has kept the proceeding in abeyance. Abeyance in view of pendency of the this probate proceeding, this testamentary appeal.
Yes.
In view of
Testamentary appeal
instant
number 8 of 2023. And Mr. Alam further undertakes that the respondent will not pursue the matter till disposal of the testamentary appeal number 8 of 2023, and as such, instead of passing any order in this IA number 1681 of 2024, the testamentary appeal may be heard on merit and prayed for fixing the matter in the last week of May.
Me,
Taking note of the submission of learned counsel for both the parties, this interlocutory application stands closed, and the testamentary appeal number 8 2023 be listed for hearing.
6/5, my lord. 6/5.
Pending 36.
Much more.
Must be.
May I please, Lordship? I have filed one application, Lordship, that is IA 1842 of 24, seeking an interim injunction. Lordship, we had filed a suit before the learned civil judge court at Amingaon.
that suit is now going on. A suit was filed for possessory right, as well as the declaration of the illegal sale deeds, Your Honor, as well as the recovery of possession. For the time being, Your Honor, we had filed one injunction application also. And so far, we had two prayers before the learned trial court. One prayer was for restraining the other side. So far, the permanent nature construction is concerned. And second one is not to alienate the property during pendency of the suit. So far, the alienation was concerned, that is granted, Your Honor. That partly our injunction was granted. And so far, the permanent nature construction was not granted. Taking advantage of that position, Your Honor, the other side has doing the total construction they have done, Your Honor, and so far the nature and character of the suit land is that was primarily agricultural land, Your Honor. It was completely assimilated, Your Honor. Nature character has already been changed, Your Honor. We had the Khotian from the days of 1954. In the year 1954, in the name of our father, this Khotian was granted. In the year 1974, another Khotian was granted. And our Khotian is not yet cancelled, Your Honor. Thing is that, Your Honor, we have still the occupation of the land, Your Honor. But so far the suit land is concerned, they have already taken away from our possession in the year 2023, in the month of January, Your Honor. That's why we have paid for, Your Honor, possessory right until we will dispose it, Your Honor. Recovery of possession. In the meantime, 2 sale deeds has been executed in their names. It is purely agricultural land, Your Honor. If your Lordship may kindly see our annexers, Your Honor. We have annex here with certain annexers, Your Honor. Lordship may kindly see Annexer 1. Annexer 1 is the sale deed in favor of the defendant opposite party number 1 and 2. And Annexer.
Mr. Alam, maintain your status quo till disposal of this FIO.
Your Lordship, I cannot see, they have paid for injunction, my lord. First of all, Your Lordship, I cannot consider what for suit is, my lord. Suit is cancellation of our 2 sale deeds, my lord. Sale deed executed in favor of respondent number 1 and 2. Those are under challenge, those are yet to be cancelled, my lord. We have bona fide purchase on valuable consideration of the suit property, my lord. Secondly, my lord, they have paid for recovery of possession before the trial court, my lord. Admittedly, as of that, I am in possession, my lord, by virtue of registered sale deed having mutation thereof, my lord. And they have paid for injunction, my lord. Trial court has granted injunction subject to outcome of the suit, my lord. Subject to outcome of the suit, my lord. If they succeed in the suit, they shall get the recovery of possession, my lord. With the question of any further injunction, my lord. Lordship, I cannot see the page number 73 of this appeal, my lord. Page 73 of FAO 50, my lord. Operative posting. Page 73, the operative portion of impugned injunction order, my lord. Page 73, my lord. Last paragraph. In view of the above discussions, it is found that it is a fit case to grant temporary injunction whereby OPs, their men, agents, persons claiming under them are restrained from alienating or encumbering the suit property in any manner till disposal of the title suit. Any construction that takes place over the suit property shall be subject to the final order that will be passed by this court in the suit, my lord. So they are well protected, my lord. Their subject matter is well protected, my lord. And there is no record on, nothing on record to substantiate that I am carrying on construction of the suit property, my lord. Not a single document is there, my lord. I am purchaser of the suit property, my lord, by valuable consideration by registered sale, my lord. I am possessing the same. If he succeeds in the suit, my lord, he will get the property through the court of law.
No, his contention is that this construction is going on.
No, my lord. It's permanent nature construction is going on.
my
lord, not a single. We have given one annexer also.
Single document
is there, my lord. Lord, if you kindly see the one annexer, I will just refer here. That is page 63, your lordship, I cannot see. There annexer 7, 8, my lord. Page 63. Yes, page 63, yes.
Yeah.
Can it be said, my lord, from perusal of this photograph is relates to the suit property, my lord, and date of taking this photograph, my lord? These were done, my lord, prior to filing of the suit, my lord. We don't have any intention to transfer, inlet, develop this land, my lord. And this has been placed on record before the trial court in our WS. WS has not been annexed to that memo copy, my lord. WS is enclosed here, probably. Our WS has not been annexed. Only plaint has been annexed, my lord. In our WS, specifically, we have placed before the trial court, my lord. We don't have any intention to raise construction of any manner over the suit property. And whatever, my lord, our feeling was that prior to filing of the suit.
So, Mr. Sharma, when
Yes,
this photograph
Lordship.
was taken?
If your lordship properly peruse this impugned order, which is passed, Your Honor, against me, Your Honor, so far the construction portion is concerned, learned trial court has admitted in its justification, it is admitted that if any construction take place, construction is already going on when the suit was filed. When the injunction matter was taken up for hearing, that time construction was going on. That's why learned trial court come to a finding that if any construction is take place over the suitlet, shall be subject to the final result passed by this court. That means the construction already taken place. Court has admitted. If any construction is going on, what we had raised before the learned trial court, that has been admitted. The temporary injunction so granted in terms of order passed alive in view of this court will meet the ends of justice. That means, Your Honor, so far the alienation part is concerned, that is admitted. It has been, Your Honor, restrained. So far the construction part is concerned, because it is a purely primary agricultural land, lordship.
Mr. Sharma,
Yes.
Mr. Alam has categorically submitted that this photograph is prior to granting injunction.
Yes, lordship.
After injunction, he has not undertaken any construction.
Yes. Then let there be a status quo order directing both parties. Let there be a status quo order as on date, Your Honor. Otherwise, I will withdraw my FAO also.
No.
FAO also, Your Honor. FAO is basically on that point only. So far, the remaining portion of the injunction prayer was concerned, Your Honor. That is only. It can be so today itself, Your Honor. So far, if he concede before the honorable court that if he does not go for the further construction and what is picture is given as an annexure 6 or 7, Your Honor, that is prior to the filing of the suit, then I will withdraw my case also, Your Honor. Because I am ready. So far the contention is concerned, Your Honor, learned trial court itself has admitted, if any construction is going on, that will be subject to the result of the suit.
No, Mr. Sharma, it does not mean that the trial court has admitted the same.
Because picture was given before the learned trial court, Your Honor.
Takes place, my lord, in future.
Lordship, any concern that take place over the suit place shall be subject to the final result.
No,
Lordship, it goes against the spirit of CPC also. Against the CPC, what is stated, Your Honor? Order 39 rule 1.
Please listen to me.
Yes.
When this photograph was taken?
It was taken at the time of institution of the suit, Your Honor.
Institution of the suit.
At the time, in the year 2023, month of January, Your Honor.
What document you have to show that after granting of injunction, this construction is going on?
Lordship, think is there. It is a purely agricultural land. They have admitted.
No.
They have passes. Lordship, they are seldom make any visit. What permission is been given in their favor, Lordship? It is mentioned in their documents.
If you are not listening to me, then I will not hear the matter.
Lordship, Annexure 3 may kindly be seen, Your Honor, of IA, Your Honor, 184.
This matter before any other bench without me.
Lordship, may kindly see the matter, Your Honor. Annexure 3 may kindly be seen, Your Honor. Lordship, may kindly see the Annexure 3, Your Honor. It is mentioned here.
I am asking you, what document you have to show that
this document I have, Your Honor. This document I have enclosed and with a 184 to IA. Annexure 3 may kindly be seen, Your Honor, before passing any order. Before passing any order. Annexure 3. Of IA 1842, Lordship.
What is this?
That is the permission granted in their favor by the learned Deputy Commissioner Kamrup Aminga, Your Honor.
When it was granted?
It was granted in the year 2020. 2020, Your Honor. 2020.
When the injunction was granted?
Injunction granted in the year 2024 in the month of March. 24 March. Lordship, this document reflects.
This document will justify that after granting injunction, the construction is undertaken by the
Lordship, it is a not order 39 rule 2 not a violation. Lordship, may kindly consider it. Here, Your Honor, agricultural land, purely agricultural land, Your Honor. They have taken the purely agricultural land.
Sorry.
It may be referred to other bench, Your Honor.
Yes.
May be referred to that. Soon after a vacation, Your Honor.
No order will be passed to that effect.
From production list.
Lordship, and appropriate is an urgent matter, Lordship. Maybe after a vacation, Your Honor.
No. You go to the registry and approach where they will list the matter. That is their prerogative. You are before the High Court, behave like a gentleman. This is not a trial court.
Yes, Lordship, yes. I offer my apology, unconditional
No.
apology, at any bench before the civil bench, Your Honor.
No.
Maybe record.
Next.
I will not hear any matter of you.
Item one for corrections.
No, this application, IA application is for withdrawal of the money, my lord. Lordship may kindly see page 12, my lord. That is the order, my lord. Pursuant to said
So
order, my
this
lord,
amount was deposited before this court.
already deposited, my lord, on 27/3/2025.
Whether you serve copy upon the this insurance company.
Yes, my lord, they are not there, my lord. Maybe posted on Friday, my lord.
Friday.
Friday, my lord.
No, have
In
you
their
served
absence,
any
my lord.
copy?
In their absence, my lord. They have
Have you
already,
served
I
any
have
copy?
served a copy, my lord. But even then, my lord, they are absent, my lord, on Friday, my lord.
Who is the counsel?
Mr. R. Goswami,
R. Gupta.
Raju Goswami, my lord. Senior colleague, my lord.
Mr. Sharma learned counsel for the applicant. Release the matter on Friday.
Friday.
Item 37 as last item.
Yes.
May I please be mirrored? I filed a petition for withdrawal of the amount deposited as 50% awarded amount by the respondent number 1, Lordship, Clement Lord. 5,59,000, Lordship. Deposit before the registry, Lordship.
Now you are pressing which matter? IA?
IA.
IA.
2813.
Wait one day. IA is for what purpose?
For releasing of the withdrawal of this 50% award amount deposited before the registry, Lordship.
Yes, any objection?
Lordship, this is a policy defense matter. That's
Policy?
why claimant made directed to executive indemnity bond, Lordship.
Bond.
Lordship.
Heard Mr. Agoral, learned counsel for the applicant, and also heard Mr. G.
Espego.
S. Pegu, learned counsel for the respondent opposite party. This interlocutory application is prepared by the applicant for allowing them to withdraw a sum of rupees 5,59,000 deposited by the opposite party
Insurance.
before the registry of this court person to order of this court dated 8/4/2024 passed by this court in IA civil number 1079 of 2024 corresponding to MSC appeal number 151 of 2024. Ms. Agoral submits that person to order dated 8/4/2024, the opposite party, that is National Insurance Company Limited, has deposited a sum of rupees 5,59,000 before the registry of this court, and the applicants may be allowed to withdraw the said amount.
Applicant number 1, Clement Lordship. Respondent number 1.
Mr. Pegu submits that since appeal has already been preferred for violation of policy condition, the amount may be released subject to furnishing an indemnity bond by the applicants. Taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed by permitting the applicants to withdraw the amount of rupees 5,59,000 from the registry of this court. Subject, however, to furnishing an indemnity bond of equal amount.
By respondent number 1, Lordship. By respondent number
No,
1.
there are two respondents.
Yes. But other respondent is minor, so this
bond will be given by the respondent number one.
Registry will look after it.
May I please, your lordship? Lordship, item number 43. I have left over my mistake, lordship. Please kindly presence my 43. Matter come up for first time, lordship. Order may given for notice, issue notice, lordship.
Thank you.